Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 30th, 2019. Additionally, this month's agenda has been posted on the website since Thursday, September 3rd, 2020.
Thank you. Now, if you'll call the roll.
Okay. Commissioner Joe Begley.
Here.
Commissioner Jeff Diaz.
Here.
Commissioner DJ Ferris.
Here.
Vice Chair Marcia Franks.
Here.
Vice Chair Marcia Franks.
Am I muted?
No, sorry, I couldn't hear you the first time.
Oh, I'm here.
Okay. Commissioner Steve Glenn.
Yes, here.
Commissioner John Moffitt.
Here.
Commissioner Joan Smith.
Here.
Commissioner Stacy Tribbett.
Here.
Chairman John Creed.
Here. All members present. We've not been able to say that for a long, long time. Glad to have everyone here.
Just as a reminder, everybody, if you can put yourselves on mute when you're not talking, that'll help us get good audio quality here.
Thank you, Dustin. With that said, at this point, we'll ask Commissioner Torbett to lead us in a prayer and then the pledge to the flag. Stacy.
Thank you. Dear Heavenly Father, I thank you so much for the opportunity to be here. I ask that you be with us today. Help us to honor you in what we say and do. In Jesus' name, amen.
Amen.
Pledge. Stand up. Pledge allegiance.
Pledge allegiance
To the flag.
to the flag
To the United
United
States
States
of
of
America.
America. And
And
to the
and to the
republic
republic
Which it
for
stands.
which it
stands,
stands,
One nation.
one
one
nation,
nation,
Under
under
God,
God,
indivisible, with
indivisible,
justice for all.
with liberty and justice for all.
justice for all. Thank you,
Sorry,
Stacy.
my Siri picked up and was transcribing that.
All right, Anna, we have to read into the record a statement of necessity and see if we agree to adopt that statement.
Okay. This is an electronic scheduled meeting of the Tennessee Real Estate Commission. Notice of this meeting was posted to the Commission's website on Thursday, September 3rd, 2020. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code annotated section 8-44-108B2, which states if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code annotated section 8-44-108A3 defines necessity as matters to be considered by the governing body at the meeting required timely action by the body, that physical presence by a quorum of members is not practical within the period of time requiring action, and the participation by a quorum of members by electronic or other means of communication is necessary. As stated, this is a previously scheduled meeting of the Tennessee Real Estate Commission that is now being held via Cisco WebEx. The purpose of this meeting with members attending by Cisco WebEx is to conduct regular business of the Commission, including but not limited to education report, executive director's report, and complaints. Furthermore, it is necessary for this meeting to be held electronically in accordance with Executive Order Number 16, issued by Governor Bill Lee on March 20th, 2020, further extended by Executive Order Number 60, issued on August 28th, 2020, to ensure government continues to function open and transparently during the COVID-19 emergency, while taking appropriate measures to protect the health and safety of citizens and government officials. Voting will be conducted by roll call.
Okay, so is there a motion to accept/adopt this statement of necessity?
So moved.
It looked to me like Steve made the motion to accept, Marcia seconded it. Now is there discussion? I hear none. Let's take a vote. Caitlin, and all votes today, as the last few meetings, will have to be done by roll call. So if you're in favor of adopting the statement of necessity, vote yes. If you're vote no. Caitlin?
Okay, Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. So the statement of necessity is adopted by unanimous vote. We're now on to approval of today's agenda. Are there additions, deletions, comments? Ms. Franks?
Mr. Chairman, I would like to add, under commission discussion, a little discussion about how we prepare for these TREC meetings, please.
Okay. Anything else, Marcia?
No, that's all.
Any other commissioners? Hearing no other comments, is there a motion to accept the agenda as submitted with the one modification offered by Ms. Franks? Joan Smith makes that motion. Jeff Diaz seconds it. It's kind of cool. I can do this whether you know if you're doing it or not. Okay, the motion is to approve the agenda as amended. If you're in favor of that motion, when Caitlin calls your name, you'll say aye or yes. If you're opposed, you'll vote no. Caitlin?
Okay, Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
You're muted, Joan.
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John.
Aye. All right, the agenda is approved, and we'll move now to the approval of last month's minutes. Discussion or a
Move to
motion?
approve.
A motion by Ms. Franks,
Second.
second by Mr. Diaz. I've lost my screen. Is there any discussion on the minutes, the motion? If not, Caitlin, please call the roll. If you're in favor of approving the minutes of last month, please vote aye. If you're opposed, vote no.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Would I need to abstain since I was not there?
You do whatever you're comfortable with.
I'm going to abstain since I was not there.
Perfect answer.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Aye. All right, so that item is handled. Next up is an informal appearance, Anthony Willoughby. Mr. Willoughby, are you on the line? Caitlin, are we expecting him to appear in person?
No, he should be appearing via WebEx.
Would you say that again?
No, he should be appearing via WebEx.
Okay, he's not here right now, apparently. We'll come back to him.
Okay.
Okay, let's go on to reinstatement waiver requests. The first one is Grant Hessman, and commissioners, you have that request in writing. Included an email from Aaron Smith last week. You might want to take a second and pull it up if you don't already have it up.
On which document is it?
I'm trying to get to it myself.
It should have been titled 04 Hessman.
Got it.
It's an email from Aaron Smith sent on September 3rd at 4:37 or 3:37, just depending on your time zone. And it should be titled Hessman, Tennessee Commission Letter. Everybody have it? Okay, let's go, Caitlin. Let's talk about it.
Okay, this licensee reached out since our last meeting. I gave the licensee the laws and the rules and explained our process, and they asked to be presented before the commission. I had given the rule that after a year of license expiration, one must reinstate, and that's the case with the second one as well. But both of these licensees still wanted to be presented to the commission and present their case. So that's why they're both on the agenda tonight.
Okay, comments, Commissioner. I mean, the first letter from Mr. Hessman is a tough letter. He's had a tough set of circumstances, but maybe someone else can figure out a way that we can circumvent the rules to reinstate a license, but I don't think it's a possibility.
Is Mr. Hessman not with us this morning?
No, in these cases with the medical waivers or this type of request, I just have them send a letter to the commission as well as their supporting document.
So may we ask Anna, I agree with John, this was just worst case scenario for this man and his family, and give my sincere sympathy for the loss of his child. Anna, is there anything that we can do? Anna?
Yes, hold on one second. I don't think so. His license expired in 2017. And that's well over the 1 year date. It is more than 3 years ago. And I don't think there's any way we can waive that. It wouldn't fall under any of the executive orders because the 1 year would have been in 2018, so 2 years prior. I don't see a way that we can circumvent it.
Other comments? So, Caitlin, let me ask you this. If we can't waive it, and I don't think we can. He has to reapply to get his affiliate broker's license, which is what he had. Does the education he's already taken take care of? I mean, is that some solace that he didn't have to go through all that education again?
Yes, as long as he has, which I believe he does, based on his original license date, have the 90 hours of pre-licensing that's currently required, he would not need to take that. He would just need to meet all education requirements once licensed.
And set for the test again?
Yes, yes. Sit for the test again and then meet all other current requirements, be re-fingerprinted, get E&O insurance, affiliate with the firm, all of those requirements that go with an active license.
So, Anna, for the record, do we need a motion on this, or can we just, if we take no action, the rule controls?
I don't think we have to have a motion. We can just choose not to take any action on the matter.
I mean, I'd glad to accept a motion to reject the request of Grant Hessman. If someone would like to make that motion, just officially for the record.
Hey, Commissioner Ferris. I appreciate the rules and how we need to let those control. I'm looking at this letter and I take this, I don't know Mr. Hessman, but he appears to be an active member from the Realtor Association and likely would have remained so had this incredible tragedy not occurred. I feel a little burdened that we can't help him out in some way. And I mean, not to give him a complete pass, but other than what all will be his burden if we reject this? He'll take the test again. He'll incur some fees. Am I following all that correctly?
Caitlin.
So once somebody's expired over a year, they would be required to retake the test, depending on what their license is. That would either be affiliate broker or broker. And they would have to get re-fingerprinted and then meet the other requirements. It would just be the initial licensure fee, no other additional fees. And then E&O insurance, firm affiliation. Am I missing something? Just the requirements that are all active licensees are responsible for, in addition to the tests and the fingerprints.
So, thanks, Caitlin. So, based on the letter that was sent earlier in the week and then documents provided, he was thinking that his broker had submitted everything, but he just failed to pay the continuing fees since 2017.
Yes, and I try to promote this a lot because there is a common misconception that if you put your license into retirement, that's all you have to do. But based on our law, you have to continue to renew your license once in retirement.
Right.
You also can't go into retirement unless you have an active license. So I see a lot of people try to go into retirement right after they expire. But you have to have an active license in order to go into retirement. And then to maintain that retirement, you have to continue to renew it. It is in the laws and the rules, and it's on the form. I'm sure some people wish that it was maybe a little bigger on the form, but it is on the form, and we've actually recently changed it to where the licensee has to answer a question that says, do you realize that you have to continue to renew your license? So we have updated that within the last year to try to make people more aware that just putting your license into retirement is not is not all you have to do if you want to maintain that status.
Mr. Chairman,
Yes, Steve.
question of Caitlin or Anna. Assuming his license expired at the end of 17, roughly, were his principal broker to pay him a commission in 18 or 19 with an expired license, is that illegal, or what's the situation there? And then I guess the other comment I would make is I've had two people reach out to me in not similar situations, but expired licenses. And at the end of the day, they ended up renewing, that one was out 3 years, one was out 4 years. And, we weren't able to adjust anything other than what's in the rules. So at some point I'd make a motion that we deny this individual. Our heart goes out to him for his situation, but we don't know of our licensees out there, other people that have dealt with equal situations and have not had this situation come up, meaning let their license expire. So that's just my thoughts.
Let's get your motion on the floor. Is there a second to the motion? Okay, Jeff, thank you. So the motion is properly on the floor. Now, Steve, you asked a question about the broker paying commission after a license has expired. If the commission, this is my opinion, but if the commission was earned while the fellow was actively licensed and now he's not, you can still pay a commission. If he died, as an example, his widow could be paid a commission if the commission was earned prior to the license expiring.
Yes, that's correct. So we have a specific rule, Rule 1260-02-0.39 about commissions earned by affiliates, and 1D talks about the affiliate allows his or her license to expire. So there's still, a principal broker can still pay their commission after that.
As long as they earned it when they were licensed, correct?
That's correct.
But if he took a listing in 2019, I'm making this up, and his broker paid him a commission, his license is expired in 17, so there's no carryover or earning accrual or anything like that, then that's not correct. Now, he shouldn't have done that, right? Or he or she, being the principal broker.
Right. That would be considered unlicensed activity, since they don't have a license at that point.
And so you might have a problem with the principal broker as well as the unlicensed individual. Marcia.
Caitlin, I noticed in both of these requests that they said they got no notice that their license was expiring. And I know that the state is not required to do that. My license was expiring in last August, and I did get a notification about it, as did another one of my agents in my office. So is it now standard practice that we send out notice to people that their license is expiring?
Yes. And in both of these cases, the first one, he was expiring right as he was trying to retire. So the notice, I believe, was sent in December prior to him putting his license into retirement, prior to him trying to put his license into retirement. And so there was a notice sent. It just wasn't probably sent. It was sent in December, and he tried to do this in February.
And do you send it to a firm address or their home address?
So if they are in retirement, it goes to their home address. And if they are in an active status, then it would go to their firm. And I believe on the second one of these, we did make multiple attempts to reach out about her renewal notice, but her address was not correct. And so we got the return mail and then attempted to reach out via email, and her email bounced back. So in those scenarios, we did make multiple attempts, and the file even says that we attempted to call. So in that scenario, there's only so much we can do if the mail gets returned and the email bounces back.
So that
and
is
I
your
believe-
office policy going forward, that you do try and reach out to people as their licenses are expiring?
Yes.
Okay.
So the way it works
That's good.
is each licensee's renewal opens 90 days prior to their expiration date. So anyone can renew as far out as 90 days. And so when our system opens that renewal, it also generates a renewal notice to that licensee. And it goes to the firm they're affiliated with if they're active, and then their home address that they've given us if they're retired.
Thank you.
John, I think you're on mute.
If there's no other discussion, we have a motion on the floor, and that is to reject the request of Grant Hessman. The motion has been made and seconded. Is there further discussion? And I realize it's with regret, but I don't know that we have a choice. If you're in favor of the motion, you'll vote aye. If you're opposed, you'll vote no when your name is called. DJ, do you have something else before we voted?
Thank you, Chairman. The only thing I'm just looking at is how much responsibility might the broker have in this? Because it says we handled the paperwork and fee to retire his license. And I guess they weren't communicating or didn't better maybe inform him that he had to do anything else. I wonder if Mr. Leadbetter didn't know about this as well, which is his responsibility maybe as the principal broker to know that you've got to pay this every month. And based on his letter, it sounds like he thought it says, so we here at Keller Williams handled the paperwork and fee to retire the license. So I don't know. It is regrettable. Understand Commissioner Glenn's remarks and yours, Chairman. So that's all I have. Thank you.
Okay. Other comments? Again, once again, if you're in favor of the motion to deny the request, you'll vote aye. If you're opposed, you'll vote no. Caitlin?
Okay. Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffitt,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease. John, I believe you're on mute.
So next up, that motion passed unanimously. Next up is a request from Pamela Robinson. You also have her letter in the same email from Aaron Smith, dated September 9th, 2020, if you'd like to find that, just so you have a reference. It's captioned Robinson request for waiver. And if everybody's ready, Caitlin, just a little background.
So this is a somewhat similar situation with this licensee going into retirement and then failing to renew her license. Her claim is that she was told she was all good. We don't have a record of that. Our phone records don't go back that far. And so I explained that over 1 year, a licensee must retest. And again, that is on the form to retire your license. It does quote the statute that says a licensee must continue to renew in retirement. But that's the essence of this request.
Okay, comments? Marcia?
So Caitlin, her license expired 18 months ago. Is that correct? She's over by 18 months.
Yes, it expired
Okay.
in March of 2019. And it was a similar situation with her going into retirement right before expiration.
The other thing, sadly, about both of these cases is it is the licensee's responsibility to take care of their license and make sure that it's timely done. I hate that this happened to this lady also, but according to Anna, if we could have made as an exception, we would probably, but I don't think that we're allowed to. And for that reason, I would make a motion that we deny this request.
I've got a motion by Jeff Diaz, a second by Jeff Diaz, just barely beat out Joe Bagley for the second. So the motion on the floor is to deny the request of Pamela Robinson. Is there discussion? I hear none. Caitlin, let's call the roll and see how the vote goes.
Okay, Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Frank,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Greaves.
Aye. So that motion passes unanimously. Let me, hey, DJ and Joan and any other commissioners that want to listen to this. This issue is one of the most prevalent issues I've had to deal with. I'll get a voicemail that'll say, hey, this is so-and-so, and I've got a little problem with real estate commission I need you to help me with. And I know what the problem is since expire. And so I call them back and I say a little prayer that surely they haven't let it expire for more than a year, because once it's past that year threshold, they've got to start over. And some of these guys are old heads. They've been around 30 or 35 years, and they may even been grandfathered in, and they're going to lose their grandfather status. They're going to have to take tests over again. They're going to have to get fingerprinted, which they really don't like just because they don't think they should have to. So anytime you are talking to a group of real estate agents, if you happen to talk to a board or somebody asks you to come speak, you can't speak on behalf of the commission, but I urge you to tell them, make sure your license gets renewed in a timely fashion. It's not the responsibility of the real estate commission. It's not the responsibility of your parents, or your broker, your sister or brother. It's your responsibility. You guys are independent contractors running a business, and you need to take care of business. Period. Done preaching. Next item.
Amen.
Mr. Willoughby, have you made it onto the computer monitor? Mr. Willoughby? We'll try again shortly. Let's go to the Education Director's report. Ross White, show yourself.
Mr. Chairman.
Show yourself.
Mr. Chairman, can you see me?
I can see you.
I cannot believe it's been an entire month since we have met. But it's just new time, new normal, huh? I want to say good morning to everybody, and I'm going to present the education report this morning for September 9th. I've reviewed all the providers, the instructors, and the courses for this morning. I present them to you and the report that you have before you, S1 through S29 for your approval.
Mr. White, is it your recommendation we approve S1 through S29?
Yes, sir, Mr. Chairman.
Is there such a motion?
Move to approve.
I've got Jeff Diaz first, Marcia Frank second. Now, before we go to a vote, are there any courses that any commissioner would like to pull out of that motion? All right, I see no indication that there is such a request. So with that said, the motion is to approve the education director's recommendation for courses S1 through S29. Caitlin?
Okay, Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Aye. All right, that motion passes unanimously. Next, Ross, you've got 5 instructors.
Yes, Mr. Chairman, members of the commission, I present the 5 instructors to you this morning before you on the instructor background sheets.
All right, any questions for Mr. White before a motion is put on the floor? If not, is there a motion?
Motion to approve.
Jim, did you want to make a second? Okay, motion by Mr. Diaz, seconded by Ms. Smith, that the education director's recommendation be adopted and these 5 instructors be approved. Ms. Maxwell.
Okay, Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Commissioner Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Aye. That motion passes. DJ, did you vote aye or did you pass?
Voted aye.
Thank you. That motion passed on 9-0 vote. Those instructors are approved. Mr. White, what else do you have for us?
That's all I have this morning, Mr. Chairman, members of the commission. I appreciate it.
We appreciate succinct reports too. Thank you.
Thank you.
Mr. Willoughby. Mr. Willoughby. We'll keep trying. Let's go to the executive director's report. Caitlin.
Okay. So I just have a couple things to update the commission on. The first being, I know there was a lot of questions about PSI last month, and they have started to send me a weekly report with how far testing is in each location. So they send it to me on a weekly basis. So for last week, I'm going to pull up my report. The next testing date, so Chattanooga was actually the furthest out, and their next available was 9/26. Jackson was 9/4. Now, granted, this was last week, so and they had 111 seats available. Johnson City had a next availability of 9/14. Memphis of 9/3, and they've actually added another location in Memphis. And then Nashville's next available was 9/13. Dyersburg 9/3, Knoxville 9/3, and then Cookville 9/23. So still a couple weeks out in certain locations, but they have added more availability. And with each of those, they let me know how many seats are available as of that date. So in the big cities, such as Nashville and Memphis and Knoxville, we are getting more test dates and a quicker availability. So this was sent to me on 9/2. I've asked for this week's report. So if I get that before the end of the day, I can let you know what it is today. But they are sending me this on a weekly basis. which is helpful when we receive calls and can let candidates know kind of what it looks like across the state. Any questions about that? Yes.
So Caitlin, if someone calls in and they ask the people where they call in, do they have the information of what's open, or you just send them to the PS website, or how's that work?
So we can schedule a candidate to take the test if
Oh.
they are out of, I'm sorry, we can put them into PSI's system. We
Okay.
cannot actually schedule them.
Okay.
But we only do that for out-of-state candidates, for retest candidates. Otherwise, if they are an initial candidate, they must be registered by the provider to confirm that they've taken the pre-license course. So we can only help get them information from PSI or get them to PSI.
Okay.
I think I mentioned this last month, but PSI has switched to a dedicated number. So they've given us a new number that is just for real estate. And so that is hopefully helping as well. Before we were in kind of a group number where we were calling with cosmetologists and other professions. This is not only faster, but also I think the goal is for those that are answering the phone calls to become more subject matter experts on just real estate.
Thank you.
Okay, Caitlin, what else?
So the only other thing I wanted to mention, I know last month we presented the Kentucky agreement with Ohio. We have been working over the last month, but it's not in a form that I would like to present to the commission. We've established at least 6 areas from that agreement that would need to change based on our laws and rules. So we're working right now to update those sections to reflect our laws and rules. So I'm hoping that in October, by then we can get those redrafted to fit our requirements, and then also get Kentucky on the same page before presenting it to the commission.
Good. Well, that topic fell under commission discussion. So without objection, I hope there's no objection. Let's move on to education courses in the October meeting, since you mentioned those.
Okay.
We've still got requests out there for virtual education courses to be approved through 2021. Anything new to report on that?
So this was more in regards to a follow-up conversation to remote classroom courses being offered. And right now that is effective through December 31st of 2020. We've been having a lot of discussions with a lot of department discussions on this topic. And I think there is still a question of whether there would need to be a rule change in order for us to move forward with this. And so right now, we feel comfortable that the executive order covers this, which goes through the end of the month. But we are still having discussions about whether a rule change would be necessary in order for this to be a more permanent option.
Marcia.
So I was the one that made this request, and I'm not satisfied that we can only go through the 21st. And I'm wondering why those conversations weren't had and a decision made by whoever makes those kind of decisions, so that we can vote on this today. Because all of these education providers are trying to line up their education for next year, and we're just holding them up. So who makes this decision, and when can it be made?
I think part of the problem is that I don't think everybody essentially agrees on next steps and what needs to be done. Right
Who is
now,
everybody?
so this is involving legal, this is involving, you know, the administrative side as well. So right now, the way that the statute is written has a RILO as an approver of distance education. This would fall under distance education because there's time and space between the instructor and the student. And right now, for a distance education course to be approved, they're required to have the ARILO certificate. You might speak to ARILO's standpoint on this. We are looking for ways to make this more permanent because we see the benefit for the provider and for the candidate. We're just trying to do it the right way.
And it's not just for candidates, it's for continuing education. It's every class that, and TREC is holding up that whole train. I can tell you from a RELO standpoint that every day we're getting hundreds of classes that are wanting to be approved. I appreciate the state of Tennessee does require a RELO to look at those classes and approve those classes. So at that point, then the best thing an instructor can do at this point then is to get approved by a RELO, and that case, then TREC needs to know who's been approved so we can approve those for. Can we get a list of those that have been approved that are wanting? How do we get that word out to the instructors? It just seems like this is something that TREC ought to have purview over, because we're the real estate commission, and we decide what classes are taught. We decide who the instructors are, and now I just feel like we're being held up by people we don't even know their names. Who are not allowing us to go forward with the education for 2021, and it's not acceptable to us. It's not. We want the education because of the public. It serves the public, and that's what we're here to do, is protect the public and more education. I don't know why anybody would want to hold up that there be easy ways for education. This is, we're in virtual world now. Every state is doing this. So Tennessee's going to be left behind if we don't do something about it. And I would hope at least by the next meeting that we can do something definitive about it. Thanks. That's my preaching.
So, Marcia, one of the criticisms I hear of getting approved by a RELO is the RELO charges too much money. Can you work on that end of it?
I can, but I mean, we pay doctors of education to go over these classes, and it's not just we get a fee. They look at each individual class, and we actually have 4 people that do that. So they're working as they can, but I can say something about what it costs. But I can tell you that the money is going to those people that we have to pay to approve them.
So
it's not a committee at RELO that's approving. It's real people with doctorates in education.
Gotcha. So Caitlin, so if legal and administration finally decides that for this to go forward, we have to have a rule change, wouldn't it be smart to at least get us a draft rule put together for next month so we can at least get that train started, if that's the case?
If that is the case, and I think the question boils down to synchronous and non-synchronous.
Wait. Too big a word. What does that mean?
So in the past, the courses that required a RELO certification were primarily non-synchronous, meaning that you could go on at midnight and take this course. It was an online course that you could start and you could stop. It wasn't live. And, Ross or Anna, chime in if you would say it differently. But it is a course that is remote that you can sign up, take whenever you want to take it. It's not a live course like what many providers are offering right now, where they're essentially replacing the classroom course that was being offered on 9/15 with a Zoom course. And that would be synchronous, because if a student wanted to take that course, then the only way for them to get credit would be to be there on 9/15, be present, follow the requirements of, being in their seat for 50 minutes out of the hour, being there for the duration of the course, all of those things. So that is the question, is whether it's just non-synchronous courses that are for Arilla's approval, or if it's synchronous as well.
Okay.
That's essentially correct. I'd like to say one thing. Yeah, it's simply that classroom courses are being given the alternative during this new normal that they be presented by Zoom. So it's the same thing essentially, although an alternative. And it's called synchronous because it happens at the same time. Whereas before, in our rules, we do have something called webinar. Webinar is an approved format, but the webinar has to go through Arello, and that's a synchronous type course as well. So webinars and this new Zoom that we're allowing as an alternative, they're very similar in that way. Whereas versus asynchronous courses, they're internet courses. And you can take your internet at night or weekends or whatever, but you're not there personally with the person, with the instructor, and the school at that time. So that's kind of the difference.
John?
Get Jeff for a quick question.
Excuse me?
Let me get Jeff, and I'll come to you, Marcia. Go ahead, Jeff.
So I just wanted to ask a question. Think about a hybrid solution. If a classroom course is offered with a live streaming option, does Arello have to certify that class in a synchronous environment? Mr. White.
That really is a legal consideration that they're going through now. That's what they're really trying to nail down. But I would think that the idea, you got to think about that synchronous thing. A classroom course has been allowed to be presented by Zoom. It's simply an alternative. So it's not really spelled out in our law that's permissible, although I certainly think during this time, it helps a lot of folks to get their CE done. It helps to get as well their pre-licenses done. So it's a very, very good thing to have at this, certainly, and through 12/31 of this year.
So in a hypothetical situation, if an instructor is standing in a classroom and nobody shows up for the classroom, but there are students joining virtually, is that still a classroom synchronous course?
I think that's what we're all kind of trying to answer right now, which is why we are delaying you, is we're trying to determine where synchronous falls and where non-synchronous falls, and where this new technology that is really not, the statute wasn't written when Zoom was an option.
That's right.
Anna had some additional.
Well, I would think the basic definition of synchronous is that the course has a definite start time and a definite end time, and it's not offered again after that by that instructor.
So what it comes down to is that our statutes and rules never contemplated this pandemic ever happening, which we all know is something that no one really can foresee these types of issues. And I apologize that we're having to delay this, but one of the issues is we want to make sure that we get this correct. So if this were to be a more permanent thing, that we don't have to come back and correct something later. We don't want to make too hasty of a decision before making that. And I understand there are certain time circumstances, but like Caitlin said, we certainly do have the ability to do that through the duration of the executive order. There may be some other legal concerns that are even above me that are being considered. So I'm not the only person looking at this. My supervisors are looking at this as well. This issue that we want to make sure that we avoid, because one of the issues that we concern ourselves with is that anti-competitive issue. Is we want to make sure that's not what's happening here. Just the way that our statute is written, it doesn't really contemplate what we're doing, and we want to make sure that we do it right, and that if it has to be defined by rule, that is something that we can do. So we're not the only entity or program that's in flux at this time. A lot of people are trying to figure out how to do this. So if you think about it, our statutes were written in the 70s. So this is not really something that was ever contemplated in 2020. So we're just trying to figure out the certification part, what to do with synchronous and asynchronous courses. We will make sure that those conversations will take place before October. And if there's some other hang up that you guys will be involved in it, so we don't have this, but we do have people working on the issue. It's just not going as fast as we thought it would be. And we're trying our best because a lot of people are relying on this, including our licensees and the commission. So, but this is something that we are taking very seriously and is very important.
Thank you, Anna. Marcia?
Yeah, so for the commissioners who are new, a rule change is not something that happens in a month, 2 months, 3 months. A rule change takes quite a bit of time, months. I would suspect till after the 1st of January. So, I mean, all I can say is to legal and whoever else is making this decision that it is imperative that you put this at the top of your list of priorities, because this is holding up 40,000 people in the state of Tennessee who need education. So please, we'd like to know something by the next meeting, if you could put this as a priority. The other thing I wanted to say too is Arello is having our annual meeting this month. And on Monday, September 28th, from 3 to 4 is the Education Issues Roundtable. So I would love to see Anna and Caitlin and Ross attend that meeting, and they can ask questions and get a lot of information from that one meeting. Again, that's the 28th from 3 to 4, and that's the Education Issues Roundtable. So you might be able to get some ideas of how other states are handling what's going on.
Thank you, Marcia. Let me follow up on one thing Marcia said. A rule change takes forever. We can get a piece of legislation passed quicker than we get a rule changed. I take that back. We're not proponents of legislation. Okay, we just do what the legislators tell us to do. But if somebody in this audience or anybody listening feels as strongly about this as Marcia, then perhaps using a trade association to push a piece of legislation that allows these type of meetings, synchronous meetings, to occur may be a way to go. But a rule change, I promise you, if we got it started in October, it'd be next June before we had finality, in my opinion. Okay, let's continue on with commission discussion, Caitlin. The October meeting, I put this on the agenda because I feel like we need to make a decision on this. Currently, we're scheduled to go to Chattanooga. What's your best sense of, is the governor going to extend this order again? You don't
So
know,
Anna,
but what's your best
Anna, would
sense?
you mind speaking to the way the current order is written?
Sure. So we have an executive order number 60 that expires. It has two different expiration dates. One is going to be the end of September, and then one is going to be at the end of October. And so the provisions have certain outlines for meetings that begin prior to October 1st and then afterwards. So if the meeting were to be held electronically in October, that would be covered under the executive order. The executive order extends until the end of October. So it's not something that the executive order is not going to expire prior to the meeting. This is one of the issues that I spoke with someone at the governor's office to ask. We have certain we're not the only board or program that has rules and statutes that provide for us to meet in different, different areas of the state. I know at least we have the contractors board that does that as well, but others outside this department. And it's our interpretation that if there is an emergency, we're in this state of emergency and there's an executive order that is allowing us to meet electronically for these meetings during this time period, that would cover meetings that have been planned a year in advance in another location.
Okay, so by statute, we're supposed to meet once a year in East Tennessee and once a year in West Tennessee. It's your opinion that the executive order takes us out of that requirement?
It is my opinion that because those meetings that we have scheduled a year prior, the year before, in May and then in October, are scheduled during the time period that covers the executive order, we would not have to go to East or West Tennessee during this time.
So, Commission, let's talk. That doesn't preclude us from going to Chattanooga in October, right, Anna?
You're not precluded from going to Chattanooga in October, but no, you're not precluded from going to Chattanooga, but it is not a requirement.
So what I'd like to do after this meeting today is let Chattanooga know we're coming or we're not. To reserve, we got courthouses to reserve, we've got the association wanting to do stuff for us. So commissioners, what's your sense? How would you like to proceed with October? Jeff?
I think the purpose of us traveling to East and West is so that licensees could have an opportunity to attend our meeting in person. And since that opportunity is unlikely in October, I don't feel a special need to travel to East Tennessee for this meeting. So I wouldn't be opposed to continue virtually until such time as in-person meetings can occur again.
Would you care to make a motion that we meet virtually in October?
So moved, Mr. Chairman.
John Moffett? John seconds that motion. Now, further discussion.
I would just like, if I can say something really quickly,
Sure.
If we are meeting virtually, we will most likely have a hearing the second day. As you know, we were supposed to have a hearing tomorrow. The respondent obtained counsel last week, and so that hearing was continued. I do have another pre-hearing conference with the judge tomorrow morning, and I told her I would let her know the outcome of the meeting today. So if we decide to move virtually, we will most likely, it will be a 2-day meeting.
And I caution all commissioners to know that legal expects a 2-day meeting, but judges sometimes have their own idea of what should happen. All right, Steve Gwynn.
Yes. Why would we not meet in Nashville live if we're having having to have a 2-day meeting, wouldn't it simplify the hearing and be a better hearing if it wasn't virtual? And we haven't been to Nashville since March, so why would we not? If we can do a live meeting, why would we not do it in Nashville? I can understand Chattanooga to a degree. Just a question.
Great question. Other comments? Marcia?
I'm wondering also, does the governor's order preclude our staff from traveling to Chattanooga also? Because we can't do it without Anna and Caitlin and.
I do know that there are certain I do know that we have certain mechanisms about travel restrictions at this time, so I don't think that we would be able to go with you to Chattanooga. And I do know regarding a live meeting in Nashville, we have certain provisions for the building to be in the building at this time, since we're all operating under the governor's position. But as you know, we have been conducting hearings via WebEx. That was actually one of the things that we talked about with the judge. So it's not really an issue for the people that are meeting for that. So that is another thing that's a good point to bring up, Vice Chair Franks.
And the other thing too is I agree with Steve that first of all, I wasn't able to be on that. I know we'd said that we would pick out a date for us to have the training on a WebEx hearing, and I was not at that because I absolutely could not be at it. I haven't been trained. I don't on the commission has not. But I can tell you that hearing is totally I think John and I and Jeff are the only ones who have, and maybe John Moffett, have been at one of these hearings. And, you've got to have somebody on the commission that's writing down the conclusions of fact, the conclusions of the law. It's not like this meeting at all. And to be able to sit in the same room, especially with the judge, and really with the person who is coming before us, I feel like it's almost a disservice to them to try and do it by WebEx. If we're going to have a hearing, there's plenty of room in that hearing room for us to socially distance. I can just tell you from experience, it's going to be tough doing a WebEx hearing, and I know others are doing it. I'm just telling you, it's going to be tough.
So, Marcia, it sounds to me like you'd prefer a live meeting in Nashville as opposed to a virtual meeting in October.
I would.
Now, there may be reasons why we can't do that, including restrictions on the building. But I think my goal right now is to either get Chattanooga in or out. And is anybody here in the mood to go to Chattanooga next month? I sense no one is. I mean, I'd like to go. I got a brother down there, but I don't really like him, so it works out okay.
Well, I mean, whether I'm in the mood or not, if I have to go, I'm going to go. But I don't foresee I expect the in October, and I don't foresee us being able to meet live in October.
All right, let's Joan.
No, sorry, that was me. I was saying a determination of whether the hearing is going to be virtual or in person is also going to be a decision that is made by the judge. So that is not necessarily a decision that we have.
Okay, let's do this. Just to help staff out, help people in Chattanooga out, let's take Chattanooga, a visit to Chattanooga in October, off the table. Is there any objection to that? I don't think we need to vote on it unless somebody wants to make that motion. By common consent, it looks like that's not a good idea. And Anna says we're covered by the executive order, so we're not violating any statute. And that's really all.
But Jeff made the motion.
There's a motion on the floor.
Was the motion had to do to make it a virtual meeting, right?
No, the motion was not to go to Chattanooga.
Okay, I thought there was a condition that said we go virtual, but I'm happy if the motion is to not to go to Chattanooga. Let's vote on that. Caitlin, if you're in favor of not going to Chattanooga, vote yes. If you're opposed or want to go to Chattanooga, vote no.
Okay. Commissioner Joe Beckley,
Yes.
Commissioner Jeff Diaz, Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Commissioner Marcia Frank,
Aye.
Vice Chair Marcia Frank,
Aye.
Commissioner Steve Gwynn,
Yes.
sorry, Steve, I couldn't hear you.
Yes. Aye.
Commissioner John Moffett,
Aye.
Commissioner Stacy Torbett,
Aye.
Commissioner Joan Smith, Chairman John Priest.
Yes. All right, that motion passes. While we're on this list, Caitlin and Marcia, how we prepare for TREC meetings.
Okay. I can remember when I became a commissioner that I took an oath and they gave me a notebook and go in there and have the meeting. So there's not a whole lot of training to it. I just wanted to be sure that everybody kind of understands that when we get the packages the week before, it's so helpful if everybody can go ahead and read all those legal documents and pull out cases that you think needs to be discussed if you don't agree with a recommendation by counsel. I just wanted everybody to know that it is really important that everybody be prepared for the meeting by going through, and it's hard reading all of this stuff. And I made the fatal mistake of waiting until yesterday to do it. But it is really important that we just go through all of it. And I just keep me a legal pad with my questions and the cases I want to pull. And I don't print it all out. Some people choose to do that, and that's fine. I just found I was wasting a whole lot of paper doing that. But I just wanted to make sure that everybody understood how important it is to be prepared when we have the meeting. Otherwise, I mean, you just kind of feel lost, and everybody's input is so important to this commission because everybody is a leader in this group, and I just wanted to encourage everybody to be sure and read through all of this.
Okay, Marcia, thank you. Any comments? All right, one more item under the executive director's report, and then we're going to take a break. Caitlin, how many employees does the Real Estate Commission have at this point?
There are 11, including myself, with one of those being a temporary employee. Okay, and you all heard this referenced a minute ago, but we've got over 41,000 active licenses in the state. We've got 11 people trying to manage those 41,000 licenses. Now, that doesn't include retired licenses and expired licenses, but that's a whole lot of work for just 11 people. And so occasionally you may get a call from somebody that's upset because the phone wasn't answered quickly enough, the answer wasn't what they wanted to hear. But I encourage you to give the staff under Caitlin's management the benefit of the doubt. I think they're working better now than
ever
I've seen since I've been on commission. So don't take the side of the antagonist. Explain 40,000 licenses. That didn't, and let me say this again, that doesn't include people who are inquiring about how to get a license or how to file a complaint or what happened to their complaint. it's a big number for a small staff. Caitlin, just wanted to mention that. I think you're doing a great job, and I'm sure your staff is as well.
Thank you.
Marcia.
Yeah, I wanted to ask if Jessica Harris was back because I saw her name on one of the emails, and she works with legal, doesn't Anna?
She is now with the admin department.
Oh, okay.
And so she is still with the department. You probably
Okay,
saw her
good.
name on the emails because our policy director was out for a period of time. And she was helping with that role while.
Okay. She's great.
Yep. Okay, ladies and gentlemen, it's either 9:45 or 10:45, depending on where you are. Let's come back in 10 minutes. Take a quick break and stretch. Let's get back to work. I certainly have a quorum. We may have everyone, but we'll get going. Mr. Anthony Willoughby, have you joined the meeting? Anthony Willoughby. All right, we'll give one more chance after the legal report. All right. So we have 70 cases. Marcia, before we get started.
No, I'll wait to commission discussion is what I had. Go ahead.
Okay. So we have 70 cases, and I'm trying to figure out which attorney, whether it's Shalina or Anna or Erica, can read the case numbers in faster than the other two.
I'm not sure who's faster, but I can read those in. Good morning, commission members.
Well, you go ahead, Shalina, and if I think you're going too slow, we'll figure out how to speed the audio up.
Okay. Number 1, 2020031571. Number 2, 2020031581. Number 3, 2020029281. Number 4, 2020030281. Number 5, 2020035791. Number 6, 2020033201. Number 7, 2020026791. Number 8, 2020029031. Number 9, 2020030141. Number 10, 2020027021. Number 11, 2020030681. Number 12, 2020039431. Number 13, 2020031941. Number 14, 2020034761. Number 15, 2020036451. Number 16, 2020036311. Number 17, 2020039241. Number 18, 2020029541. Number 19, 2020029571. Number 20, 2020039111. Number 21, 2020037421. Number 22, 2020037391. Number 23, 2020039031. Number 24, 2020039151. Number 25, 2020032531. Number 26, 2020037401. Number 27, 2020039331. Number 28, 2020039581. Number 29, 2020040611. Number 30, 2020041481. 31, 2020041521. 32, 2020037821. 33, 2020032241. 34, 2020040191. 35, 2020040261. 36, 2020041031. 37, 2020041051. 38, 2020041061. 39, 2020041611. 40, 2020043181. 41, 2020040141. 42, 2020040551. 43, 2020040221. 44, 2020038521. 45, 2020041411. 46, 2020041581. 47, 2020043481. 48, I'm sorry, 49, 2020043551. 50, 2020045961. 51, 2020046491. 52, 2020038761. 53, 2020042791. 54, 2020043331. 55, 2020030081. 56, 2020003871. 57, 2018073421. 58, 2019096241. 59, 2019001581. 60, 201802, excuse me, number 60, 2018027421. 61, 2020040571. 62, 2018041781. 63, 2007, I'm sorry, 63, 2018074951. 64, 2019065701. 65, 2019084271. 66, 2019017491. 67, 2019017501. 68, 2017010631. 69, 2017010661. 70, 2018011111.
Thank you, Shalita. That was good.
Okay.
Now, I have a list of cases that both myself and Commissioner Franks have asked to be pulled out of the list. Are there other cases or other commissioners who have particular cases they would like to discuss? All right. So here's the good news. I'm gonna ask for a motion to accept council's recommendation on cases 1 through 70, with the exception of 20 cases that I'm going to list. So the good news is, if this motion passes, we'll handle 50 of the 70 cases. The bad news is we're going to have to talk about 20 of them, which is not bad news because, as Ms. Franks mentioned earlier, if you have questions or don't understand the recommendation of the attorney, the right thing to do is to pull them out. So the cases to be pulled out of the motion are cases 1, 2, 12, 16, 18, 19, 27, 33, 34, 36, 37, 38, 45, 51, 55, 56, 57, 58, 69, and 70. So incorporating those cases into a motion, is there a motion to approve the balance of the cases as recommended by council?
So moved.
Motion by Ms. Franks, second by John Moffett. Discussion on the motion. All right, let's vote. Those in favor of the motion, when your name is called, will vote aye. If you're opposed, you'll vote no. Caitlin?
Commissioner Joe Beckley,
Aye.
Commissioner Doug Diaz,
Aye.
Commissioner DJ Barrett,
Aye.
Commissioner Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Commissioner Chairman John Glees.
Aye. All right, that motion passes and those 50 cases are resolved. Let's go to case number 1. Shalina, in this particular case, it's short enough that if you would just read it into the record, and then we'll see what Marcia and I want to discuss about it.
Sure. This is number 12020031571. The complainant is a Tennessee resident and respondent is an Arizona resident and licensed Tennessee principal broker. The complainant drove by a home and saw a sign stating, quote, "Fixer upper worth $300K, price $125K, 392-1593, close quote. The complainant contacted the respondent and asked about the property. The respondent indicated the signs are put in front of new properties, but the sign is not placed in front of an actual property. The sign does not indicate a brokerage name or phone number. The complainant indicated the sign was misleading and it appeared to advertise a specific property and price, but the property does not actually exist. The violations of the Tennessee Real Estate Commission Rule 1260-02-.12, 3A. It states no licensee shall advertise to sell, purchase, exchange, rent, or lease property in a manner indicating that the licensee is not engaged in the real estate business. Then Tennessee Real Estate Commission Rule 1260-02-12, 3B states all advertising shall be under the direct supervision of the principal broker and shall list the firm name and firm telephone number as listed on file with the commission. The firm name must appear in letters the same size or larger than those spelling out the name of a licensee or the name of any team, group, or similar entity. Respondent failed to provide a response pursuant to Tennessee Code annotated 6213, 313, 2. My recommendation is to authorize formal charges and assessment of a civil penalty in the amount of $1,000 for the above specified violations.
Ms. Marcia.
Yes, so the above specified violations, you listed 3 of them. But your civil penalty is only $1,000. This is a principal broker, and we hold them to the highest standards. And for them to not respond is bad enough, in addition to these other 2 things that they've done. So I was just wondering why council only wanted to have a civil penalty of $1,000 instead of a civil penalty for each of the 3 offenses.
In this particular case, the only reason I put $1,000 was because of the advertising violation as a whole. But of course, as I've previously said, it's always at the discretion of the commission to change the penalty amount if they so choose. So if you'd like to assess a $3,000 penalty, that's fine as well.
And John, what were your concerns?
Exactly yours. I thought the civil penalty was, like $333 per violation. And I think each one of those could easily be considered a $1,000 civil penalty.
Okay, so my motion would be that we give a civil penalty to this principal broker of $3,000, $1,000 for each of those two offenses, and to require that they take the principal broker core class and not get education credit for it.
Okay. The motion, as I understand it, is to offer a $3,000 civil penalty to this licensee, $2,000 for the violation stated, $2,000 for the violation stated, $1,000 for failure to respond. And in addition to that, required the principal broker to take, is it a core class, Marcia?
It's a core principal broker class.
Okay, to take a core principal broker class within 6 months. And that class, any credit accrued will not apply to a license renewal.
Right.
That's the motion. Is there a second? Thank you, Jeff. Discussion. All right, Caitlin, let's vote.
Oh,
Okay.
Steve, did you?
yeah, just a question. If we wanted to suspend the license for 6 months, what's the principal broker's license for not responding to me is not a good thing. Is that possible, or I don't know? I don't have my book in front of me. Is that? And the second question would be: do we know how many licensees the principal broker has under him or her? I don't want to belabor the issue, but just.
So to your first question, Steve, we can do whatever a majority of this commission wants to do. So if you don't think Marcia's motion is what you like, you can make a substitute motion and see how that applies. But we can do it.
Okay. Is it normal for a principal broker to not respond at all in a situation like this? Is he just like ignoring us, or is it? Is there some kind of overt? He's kind of blowing us off and said, they'll find me and I'll just keep on doing it, or what? Or do we?
Any one of those possibilities.
And Steve, the thing about a principal broker to me is this also. Every principal broker should have an exit plan and should have another principal broker that they could call on at a moment's notice in case there's an accident or for any reason. And so this person should have someone in place. Caitlin or Anna, do we know how many agents that they are over?
I can look that up.
Okay.
I just wonder, is a suspension, if I'm the guy who's like, okay, $1,000 or $3,000, is not significant, maybe or maybe not, compared to how much I'm making. So if I had my license suspended, I'm going to keep on. Well, I'm going to make less money than I would paying $1,000 fee. I don't know. That's what I'm saying.
I think in order consistently, $1,000 is what has been given for failure to respond. I think suspending someone's license, you really can't put a price on that penalty. I don't know that it would be consistent on this one.
Okay. All right.
So that might be a question for legal. But I'm currently looking at the number of agents with her.
And Steve, it is inconsistent that we do not usually typically have a principal broker that does not respond.
So this is abnormal, is what you're saying,
That's what's
correct?
not to principal broker. It is abnormal.
There are
All right,
7.
okay.
There's 7 agents with the firm.
Okay, so we've got a motion that you've heard stated offered by Marcia, which would include a $3,000 civil penalty and education requirement. Is there further discussion?
So you could be a principal broker and live in Arizona?
Oh, yeah. It gets under Marcia's skin, but it can happen. Caitlin, let's call the roll. Let's get this case handled.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Do we have a substitute motion?
No.
Okay.
No.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Glenn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. All right, that motion passes. We're on to case number 2. And once again, Shalina, I won't do this every time, but would you read this into the record?
Sure. This is 2020031-581. The complainant this complaint was administratively opened by the Real Estate Commission against the respondent. The respondent is a licensed Tennessee principal broker. The complaint was opened against the respondent for failing to supervise an affiliate broker. The respondent provided a response and stated the affiliate broker was acting solely with the affiliate broker's own property rental business, and the respondent allowed the affiliate broker to work in the affiliate broker side business. This had nothing to do with the principal broker or the real estate firm. The respondent rents private homes for private individuals, and the respondent is not involved in any of the transactions and does not receive any kind of compensation from the homeowners or the renters. The respondent indicated the tenant is one of the property. The tenant is one of the properties did not want to pay a higher rent at the time, and the homeowner requested the affiliate broker assist in eviction proceedings. Once the tenant moved, the homeowner was upset that it had not been rented and that no income was being generated. My recommendation is to close.
Marcia, you want to go first?
Yes. So, do you have what we did to the affiliate broker? What happened to that affiliate broker?
No, I don't.
Okay. So we don't know if they were found guilty or not.
No, and I don't even know if there was a complaint opened against the affiliate broker, because this complaint came in against the principal broker.
And so the only one, did you personally, Selena, talk to the principal broker?
No, I didn't. I reviewed their response, their written response.
So all you have to go by to close this file is their response and nothing from the complainant either? Well, we are the complainant, actually.
Right.
All right. So there was a reason that the commission opened up this against the respondent.
Yes.
We don't have all the information here for us to make a real good decision, I don't think. And because this involves a principal broker, and they say they didn't know. I had an experience one time with an agent, and I called the agent, and their message was, if you're calling about one of my rental properties, call me at this other number. I didn't know my agent was doing any rental properties. So I immediately, I left a message saying, call me back, I need to talk to you about your rental properties. And he about died because he had not told me. I think, principal brokers are not God, and we are held to a high standard. So the question comes down to, should this principal broker have known that this was going on? And in their statement, they say that the affiliate was called in to help in the eviction proceedings. So how did the principal broker know that and not know they were doing property management?
In situations like this, typically what happens is the complaint against the affiliate broker was closed by the commission, and we were asked to open another complaint against the principal broker for failure to supervise. And I suspect that's what happened in this case as well. And that's why this was administratively opened.
I did pull up the other complaint, and it does look like the commission issued the affiliate $1,000 civil penalty, and requested that they complete 4 hours of continued education and contract. And the affiliate has completed that, and that consent order is closed.
So let me jump in, Marcia.
The only information we have that's new then is the response from the respondent. Is that correct?
Yes, and this respondent indicated that they were aware that the affiliate broker had this property rental business on the side and gave them permission to do it.
See, and
So
that's all.
do that.
That's all.
So the principal broker should not have done that. Yeah.
That is failure to supervise.
Yes.
Also, if you don't have E&O insurance with the rental rider, nobody's covered. It has to go through the broker. E&O insurance, the broker has to have E&O insurance on rental stuff to let the affiliates do rental stuff.
So I pulled this one as well, Marcia. In my opinion, the broker's pretty much admitted that he let him. Well, he did is, according to this, the respondent allows the affiliate broker to work in the affiliate broker side business. Well, you can't have a side business in property management without having a real estate principal broker. And that's not the case here. This is, to me, a classic case of failure to supervise. Now, what would help his case, and I think we'll see that in a later case, would be the broker, as soon as he found out about this happening, sending his license back to the state. But that's not the case at all here. He's pretty much concurred he knew the guy was doing it.
Mm-hmm. So Jeff wanted to say something.
Jeff.
Well, yeah, I think it's in line with the two commissioners, the chairman and the vice chair, saying, as an affiliate broker, all activity that I would do under my license has to be supervised by a principal broker, whether it's real estate, commercial, rentals, whatever it is. So I don't think, giving the blessing and sending the affiliate broker on his way is the appropriate course of action.
So I'd like to make a motion.
Please.
I'd like to make a motion that we assess a civil penalty to this principal broker of $1,000 for failure to supervise, and to also have them take the principal broker core class within 180 days.
Is there a second? Thank you, Jeff. Okay, the motion is on the floor. Further discussion.
Does Jeff have some kind of secret button? How's he getting all those?
He does this. You're in the shadows, Joe. I can barely see you. You're there. We go. Now maybe you'll show up. All right, let's vote, Caitlin.
Commissioner Joe Beckley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferris.
Aye.
Vice Chair Marcia Frank.
Aye.
Commissioner Steve Gwynn.
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Green.
Aye. All right, that motion passes unanimously. Number 12. Shalina, let me just summarize this one. So here's a case where a real estate agent admits that he let his clients or customers into a house on their own without him going in with them or she going in with him. I mean, that's my summary of this entire case.
Basically, except these were family members, and the respondent did let them in and just waited for them.
So I don't care if they're a clergy. If the agent just opens the door and says, "Go ahead, and when you're done, I'll be out in the car," I got to believe that's not the way you're supposed to do business. Now I'm open the floor to other commissioners to say what you think about that. Jeff.
Well, I think there has been an occasion where I've done showings for women who are by themselves where I may not have gone fully into the structure with them just because they've expressed discomfort with that fact. But in this case with 4 individuals, you just open and stand inside the door and make sure they're not stealing the little food. Well, I mean, that's my take on this case.
Marcia.
So there's obviously a family problem here. And, I dare say we all might have some family members we wouldn't want to turn loose in our homes. So I do think it was a lack of skill that this person allowed this to happen.
Other commissioners. Hey, Joan, I'm just going to put you on the spot. What do you think about this?
I think it's my responsibility to be protective of the homeowner's property. And so I think it's being respectful to go in the property with the clients or customers. But I also have been a little uncomfortable when it's only me and maybe a person that I'm not as comfortable with. But I do think I've kept my distance and been close to a door to have a little escape. But I do think that it's my responsibility as a realtor to go and be inside the house. So I just think that's being a good realtor. You don't stand outside the door and open the door and say, "I'll go on in and I'll be outside smoking my cigarette," or whatever it is, or anything like that. I just think it's not professional to wait outside. So, so I think you need to go inside and show the property. You're muted, John. You're muted, John. John, you're muted.
Well, thank you. Thank you, John. I'm going to ask DJ for his thoughts on this.
Thank you, Chairman.
You don't really mean that.
I'm trying to be the newer commissioner, having 2 ears and 1 mouth and using them appropriately. I recognize Commissioner Smith's remarks about there could be a higher level of professionalism given by this person to go in and show the house. It makes me question if the grandson and his wife and how serious of buyers they were, if they were just, kicking tires, and that's what it makes me question. It makes me recall back in my history if I've ever done this, though I can't recall any instance now. I'm not inclined to do so in the future. But you're right. It could have been, they needed to gone in and at least been in the home. And if they had a COVID concern, I don't know if this, because they did have a mask and had used gloves. Maybe there was a COVID concern. They could have at least still stayed in the front doorway or within earshot of the those viewing the property.
Thank you, DJ. Jeff?
Well, I think I'd like to hear from council what steps we're asserting that he didn't exercise reasonable skill and care. Is that where we're going?
Yes, I believe so.
Okay, thank you.
So the floor is open for a motion. And the motion may be to accept council's recommendation. We'll move on. Or maybe someone would like to make a different motion. Jeff?
Well, I noticed in the description, he talks about where he made 4 appointments, and he did the same thing at the 3 other houses. I made that admission in his response. Do we want to say that he didn't exercise reasonable skill and care 4 times?
I'd say if somebody will make a motion to that effect, we'll find out what people think. If we, Jeff, come
John?
on.
What's the fine typically, $1,000 or 500?
Well, you
No
can,
precedent?
it's up to 1,000 per violation. Steve?
John, I'm just kind of wondering in the COVID deal if that was a concern, as well as the fact that the person showing the space or showing the house knew that the owner was there and these were his relatives. I would have said, you know, is it okay for me to wait outside? Obviously, these people have been in the house before, and if we don't know whether the person showing the house asked the owner if it was okay for him to stay outside or not. It doesn't say that in there, but that's just a thought.
Yeah. I mean, I think if that were the case, Steve, he would have said so in his response.
Maybe.
And he said he did have a mask and gloves, so.
The complaint, I think, is the homeowner, so it kind of rules that out as an option. One of the homeowners.
Mm-hmm.
All right, guys, this is not a big deal. We just need something to vote on. I'd say the first motion wins.
All right, I'll make a motion that we to assess a civil penalty of $1,000 for failure to exercise reasonable skill and care.
Is there a second? Thank you,
Second.
Stacy. Stacy beat you. All right. So Jeff, just one point of clarification. Do you think that's 4 violations at $250 each? Is that?
I'm going to take the complaint as written for 1 offense.
Okay. The motion on the floor is to offer a civil penalty of $1,000, made by Mr. Diaz, seconded by Ms. Torbett. Further discussion? All right, let's vote. Caitlin.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Glenn,
No.
Commissioner John Moffett,
Aye.
Commissioner Joe Smith,
You're
Commissioner
muted.
Joe Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. All right, that motion passes. We're on to case 16. And I'd like to refer you to the last paragraph, the last full paragraph. My only issue with this case. The last sentence in the last full paragraph says, the respondent did advise his client not to sign the TR mutual release form because it could result in respondent giving up any rights to damages from the complainant for the breach of contract in the event of a lawsuit. To me, that sounds like legal advice. And if it's legal advice, licensees are expressly prohibited from giving legal advice. Shalina, what's your thought?
Yes, I agree with that. However, in this case, it was the complainant that did not close on the property.
Here's my position is, regardless of what the circumstances are, we have a licensee who apparently gave legal advice. And I could be wrong on that. The circumstances may make a difference, but to me, I thought we ought at least to discuss this topic. Marcia.
And just because the house didn't close does not take away that they did give legal advice. Whether it closed or not is not really important to this. It's that they did give legal advice.
Other comments? Joan. Go ahead, Joan.
You know, we got that disclaimer that says, I'm not. And one of them is, I'm not an attorney. And then we turn right around and say, because it could result in, and that's exactly what he's doing, is giving legal advice there. So I agree with you, John.
Well, why don't you make a motion, Joan? Make your first motion in the legal report.
Well, I do make a motion. I do, but I don't know what the penalty would be.
It's anywhere from $1 to $1,000. And
well, make a motion. I'm
offer
sorry.
you make a motion to offer a civil penalty of, and then you fill that blank in.
I make a motion that we assess a civil penalty of what would be a normal penalty. What would be a normal penalty in that situation? $500.
Well, let's say that's what you plug in there. Let's see if people like it.
Joan, I would give it $1,000 because it's pretty serious to be giving legal advice.
Okay, I make a motion that we assess a civil penalty of $1,000.
And there's a particular statute or rule that prohibits an agent from doing that. We'll let legal or somebody plug that number in. I don't know what it is. Marcia, did you second that motion? So
Yes,
Marcia
I
seconds
second
the motion. All right, discussion.
Who seconded
Marcia.
my first motion? Thank you, Marcia.
All right. The motion on the floor is to offer this licensee a $1,000 civil penalty for the unauthorized practice of law. Is the discussion? If not, let's vote. If you're in favor of the motion, you'll vote aye. If you're opposed, you'll vote no. Caitlin?
Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferris.
Aye.
Vice Chair Marcia.
Aye.
Commissioner Steve Glenn. Commissioner John Moffett.
Aye.
Commissioner Jen Smith.
Aye.
Commissioner Stacy Torbett.
Aye.
Chairman John Cruz.
Yes. Okay, that motion passes. Way to go, Joan. Got your first motion passed. Congratulations. All right, number 18. Shalina, the only question I have about this has to do with your recommendation.
Yes.
It recommends civil penalties of $4,000. But I don't know how you got to that number. So if you could tell me.
I'm sorry, that was an error. It was a failure to provide a response to the agreed citation and failure to provide a response to the complaint. So the civil penalty should be $1,000.
So what's the situation here? We offered them a civil penalty previously and they didn't respond.
Correct.
And so now you want to take them to a hearing. Is that
Yes.
right?
Well, there was an agreed citation, excuse me, issued by the commission to the respondent. And then the complaint was opened up when they didn't respond to the agreed citation, meaning they didn't pay it. And they didn't respond to that complaint that was opened, and the recommendation is to assess $1,000 penalty for failure to respond.
That doesn't affect the fact that there's going to be a formal hearing. Is that right?
Correct.
So your recommendation is $1,000 for failure to respond.
Yeah.
Okay. Is there a motion to accept council's recommendation?
So moved.
Thank you, Marcia. Is there a second? Thank you, Jeff. Discussion. At some point, in theory, we'll see this case again, right, Shalina?
Yes.
Okay. All right. The motion is to offer this respondent $1,000 civil penalty for failure to respond. If you're in favor of the motion, you'll vote aye. If you're opposed, you'll vote no. Caitlin?
Commissioner Joe Bishop,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Wood, Commissioner John Moffitt,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stephen
Aye.
Chairman John Green.
Yes. Okay, that motion passes unanimously. Number 19. Marcia's on this one.
Yeah.
I'm on this one as well.
So
got some
on
real
this
static.
So on this one, the recommendation is for a $4,500 civil penalty. So I'm wondering how council looked at this and each thing, did they get $1,000, $500? I'm wondering about the $4,500.
Because there were several violations, I mean, it could be 5,000 if you so choose. I just assessed it at $4,500.
So are there 5 violations or 4 violations? Or how many violations do you see that there's 1, 2, 3, 4, 5 violations, right?
Correct.
Okay, so what I would like to do is to amend, make, authorize formal charges and an assessment of a civil penalty in the amount of $5,000 for the 5 violations, each having $1,000 penalty. So that principal broker, because in 2019 they were before us with failure to supervise, and it resulted in suspension of an affiliate's license, that we also require this principal broker to take the principal broker core class also, in addition to the $5,000 within 180 days, and not to be considered towards their continuing education requirements.
Okay.
For a second.
Second.
Oh, my fault. Jeff, I've got Jeff Diaz, second the motion. Steve, did you have a comment?
No, I was processing, but that's all right. Do we?
Does anyone else have audio problems?
Yes, bad audio.
Dustin, can you help us?
It seems like it's only certain people.
Yeah,
I hear you fine, John.
Okay.
I think it's coming from his computer.
Which computer do you think?
Steve's.
Okay.
I'll mute it more. Is that better?
No.
I don't know what's going on.
You may want to try and call for or have your audio come from a phone if possible. I mean, we can hear you okay, but when you're trying to talk, it does kind of create a distortion.
All right. All right, let me close the door. There may be some background noise or something coming in.
Okay, thanks, Steve. Okay, you've heard the motion. Is there discussion? The motion, if passed, will offer this licensee a $5,000 civil penalty and require a principal broker core class to occur within 6 months, with no credit for that core class going toward his license or her license renewal. Discussion. If you're in favor of that motion, then you'll vote aye. If you're opposed, you'll vote no. Caitlin.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris.
Aye.
Vice Chair Marcia.
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith, Commissioner Stacy Corbett,
Aye.
Chairman John Green.
Yes. All right, that motion passes. Number 27. Next up.
That was me, John, I think.
You go right ahead, Marcia.
All right, so this was a case where the affiliate broker was doing property management, and the principal broker was the one who made the response. And that's my first question is, can a principal broker respond for a respondent, or does that respondent have to respond themselves? Anna. Anna?
Yes.
Can a principal broker respond for an affiliate broker, or does the affiliate broker have to respond for themselves?
Affiliate broker doesn't have to respond for themselves. We oftentimes have a principal broker send in a response for their affiliate as well. It's just that you have to respond in some capacity to the complaint.
Okay, so the recommendation is to authorize formal charges and assess a civil penalty in the amount of $3,000. And the three violations are listed here. One other thing that I'd like to know is this person still with the firm that the principal broker responded from?
Yes, I believe so.
Who was that?
This is Shalina.
Okay. John, did you have a question about it also?
Well, I'm gonna talk to Steve for just a second. So here we have what appears to be a clear case of a licensee taking somebody else's money and not returning it. If I was in the mood to suspend a license for a period of time, it would involve taking somebody else's money and not returning it. If I was in the mood, the principal broker here may have had no knowledge of it. And we've had cases where that was the case. We've had formal hearings where it was proven that they didn't know it. But if I was in the mood, this would be a good case to send a message. There's a lot of this going on. There are affiliate brokers leasing and managing properties on their own without that money ever getting to their broker's escrow account. And it's a clear violation of the law. So those are my thoughts on it. I mean, this guy's got money that he's taken that doesn't belong to him and hadn't returned it. I'm separating the principal broker out. You may want to talk about him as well, but the complaint is against the affiliate.
And remember when I told you a while ago about the guy who I called and told him, he was doing property management? What I did when he called me back was I released him from my company. I let him go from my company. So it worries me a little bit. I mean, who would want somebody that's taking money from other people still working at their company and doing property management and didn't tell you? So that kind of puts a light on it too. I'm definitely, but Steve, are you thinking of maybe we can downgrade for 6 months? We revoke. We can do whatever we want to.
What do you say? When you say downgrade, you mean suspend, or you just mean move to an affiliate, or what?
Well, they're an affiliate broker, so you can't downgrade them. They're at the lowest level, so you can only suspend them or revoke them.
So we're the only ones that can suspend, correct? A court can't do that, correct? In other words,
So, Steve, let me just say something.
Oh no,
we're not the only ones that can suspend. The state, for instance, if you don't pay child support, the state can automatically suspend any license you've got. So we're not the only one. But we do have the authority on our own to do stuff when you see violations.
But if this went to court, a judge is not likely going to suspend a lot, or is it? I mean, I don't know. I would think he's going to look at the law and not necessarily what the person did as a licensee of some entity within the state. So I would think that maybe a suspension for 6 months or something like that would be, something we ought to consider.
I'll make one more comment. Whatever we do is an offer. It doesn't automatically happen. The licensee has to agree to it as well. If the licensee doesn't agree to it, then we'll have a formal hearing at some future date.
All right. That's okay.
Just wanted to make sure everybody's aware of that. Okay, the floor is open for a motion.
All right, I'll make the motion. I'll make a motion that we authorize formal charges and assess a penalty in the amount of $3,000 for making a substantial and willful misrepresentation, engaging in conduct that constitutes improper, fraudulent, or dishonest dealing, and failing to provide a response to the commission on a pending complaint. And also at the same time, suspend this person's license for 6 months.
Second.
Okay, the motion on the floor offered by Ms. Franks adopts council's recommendation and in addition offers a 6 month suspension. That motion is seconded by Steve Wynn. Is there discussion? All right, let's vote, Helen. If you're in favor of the motion, you'll vote aye. If you're opposed, you'll vote no.
Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferris.
Aye.
Vice Chair Marsha Franks.
Aye.
Commissioner Steve Glenn.
Aye.
Commissioner John Moffitt.
Aye.
Commissioner Joan Smith. Commissioner Joan Smith.
Aye.
Commissioner Stacy Torbett.
Aye.
Chairman John Grease.
Yes. All right, that motion passes. Number 33. Yes, Joan.
Yes, I want to ask a question. Should a license during this period of time come up for renewal and your license is in this period of time where it's being suspended? How does that work?
Well, remember, we didn't suspend the license today. We offered that as a solution. So until that licensee agrees to it, or we have a formal hearing, the license remains in place.
Okay.
Now, Caitlin, you want to speak to it beyond that?
But should he agree to it and a license be suspended, and it's during a suspension period and a renewal period, how would that work?
I'm going to defer to Caitlin.
Okay.
So when your license is suspended, it does revert back to the status that you were in previously when you get out of the suspension. So that licensee would need to maintain their expiration date, or they would need to renew it immediately following suspension if they were still within the year. Does that make sense?
Say that one more time. There was a little bit of noise, so I missed you.
So they would need to maintain their expiration date.
Okay.
So let's just say they did expire between now and then. They would need to renew so that their expiration date moved forward, but they would still stay in a suspended status.
Okay. All right. Thank you, Caitlin.
Yes.
Good question, Joan. Thank you. Let's go to number 33. And I'd refer commission to the last paragraph before council's recommendation. This is another case, it appears to me, where an affiliate is practicing property management without the knowledge of the broker. And in the last paragraph of the narrative, as you look at it, when this principal broker found out about it, he broker released the affiliate. And to me, that's kind of the benchmark. If a broker says you know about it and it happened, and then he finds out about it and the broker releases the licensee, I have no problem with the principal broker. I do have a problem with this affiliate. In addition to the recommendations of council, maybe it's included in here, Shalina, but it appears to me that this affiliate was practicing real estate without a license for at least a period of this time.
That was my concern too. They expired in July of 2019, and they were doing this property management September 2019.
Yes, I believe that's correct. I think they may have renewed. I'll have to check quickly.
Oh,
I can check that for you.
Wait.
Hey, John,
Yeah, Joe.
the way I read that last sentence, he didn't let him go because of this incident. He let him go because he wouldn't renew his license.
You're right. I misread that. Maybe I won't give the broker a pass yet. But when was that license expired? Back in September the year before?
Yeah. And you don't have to release someone if they're already expired.
He still has an expiration date of July of 2019.
Okay, so this took place September of 2019, so it's unlicensed activity.
Yes, I believe so. That's correct. I'm sorry, I didn't see that.
And so if they're unlicensed, we can't assess these civil penalties, can we?
That's correct. It's unlicensed.
All right, I'll make a motion that we assess a penalty, civil penalty of $1,000 for unlicensed activity.
Let's put him on the watch list if he tries to come back.
I'm good with that too.
Set a second, Joe. Thank you. Okay, the motion is properly on the floor. Discussion.
Who knew I was a trendsetter?
Yes. For new commissioners' benefits, DJ, go ahead.
Thank you, Chairman. I made in my notes as I reviewed these cases leading up to today's meeting, and my notes was find more money. But I understand since he was not licensed, we can't induce these civil penalties. But he looks like he caused a complainant to miss out on a significant amount of money in my mind. So it's at least flag him, as Commissioner Begley said, at minimum, and I'll vote for the 1,000 in the affirmative.
Marcia.
Now, Commissioner Ferris, there is something else that we could do. We could look at how many properties there were, because we can assess a civil penalty per occurrence, and we can also do it per day. So, Selena, do we know how many properties they were managing?
I don't believe so. The complaint here is for one property.
Yeah, but there's 2 units.
Yeah, there were 2, yes.
Oh, okay. So I will change my motion to $2,000 for unlicensed activity.
Joe, will you second that change? Perfect. Okay. So the motion on the floor is to offer this, it's not a licensee, is he? This entity, this person, a $2,000 civil penalty for the unauthorized practice of real estate, practicing real estate without a license. Discussion. All right, let's vote. Those in favor of the motion vote aye. Oh, sorry, we're not in person. Caitlin, go ahead.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwen,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Creed.
Yes. So that motion passes. We're on to 34. Marcia.
Okay, on this one, this person has had this sign up on this listing for 5 years, since 2015. My question is, did they provide to council signed listings and extensions that go back to 2015?
Yes.
Okay, then that's all I have.
So your
I'll
motion
make a
is
motion to accept council's recommendation to close.
is there a second? Thank you, Jeff. Sorry, DJ, I'll get you next time. All right, the motion on the floor is to accept council's recommendation. If you're in favor of that motion, your name is called, you'll vote aye. If you're opposed, you'll vote no. Caitlin? Caitlin?
Sorry.
Okay.
Okay. Y'all ready for a roll call vote?
Yes, please.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz, Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torvett,
Aye.
Chairman John Bridge.
Yes. So that motion passes. Number 36, Marcia. You're muted, Marcia, you're muted.
So, this one is 36, 37, and 38, and they're all identically written. I'm wondering, was this a team, or what's the significance of them all being the same case?
Shalina, you're muted too.
I'm sorry about that.
That's okay.
In this particular case, there was a complaint filed against each of the affiliates and the principal. I'm sorry, each of the affiliates.
Was this a team?
No, they were not. They were just the people involved in the transaction, meaning the owners.
Okay, so the respondent in each of these three cases is a licensed affiliate broker, and the complainant is the person who's the property owner who has a home listed for sale, correct?
Right.
So
They were
how
the
could
purchasers. I'm
you get
sorry,
three
they're the
people?
purchasers.
I don't understand how you could, they were, it was listed by three different people?
I'm sorry, the complainant was the owner of the property, and the three people were the purchasers and happened to be affiliate brokers. But they had somebody representing them to purchase the property.
Okay, and so they were negotiating this property together, the three of them as partners.
Yes.
Okay, then my motion would be that on number 36, 37, and 38, to accept council's recommendation to close.
I have a question.
Joe, go.
So was the fourth agent that was local, or they weren't a buyer? Saying the buyer's agent was not a buyer also. There was three listing agents that lived 100 miles away. They were buying it, right?
Yes, they were affiliate brokers and were represented by a agent.
Okay, and did they use a personal interest disclosure? Do you know?
I'm not sure. No, I don't believe so. They showed that they were agents.
They did or didn't disclose?
They did not disclose because they were represented.
I think you still have to disclose, don't you? Martha, what are your thoughts? Don't you still have to disclose?
I would have to ask my attorney's advice on that one. Anna?
Yes.
So what's your advice on that one?
If you still have to disclose whether you're an agent, even if you're not
They were a
involved.
purchaser. They weren't the agent involved.
Mm-hmm. I feel like the disclosure is required. I know disclosure is required when you're the agent selling it, but I'm not sure if it extends to if you're
Buyer.
purchasing a home in your own capacity as a buyer. So I would defer to Selena's recommendation. I don't think that is something that necessarily has to be disclosed in this case. I guess my
So-
question would be, what would be if the person failed to disclose the information, the negative impact that would have?
So,
Yes.
I think Joe's right, but I don't think the fact that they didn't disclose played much of a role in this issue at all. So, if anything, I would think maybe a letter of warning to those three affiliates, just letting them know they're supposed to disclose that, would make sense. Jeff?
Elena, does the record tell you if the seller was represented?
No. The seller was the complainant.
Right, but did the seller have their own agent?
No.
So this is where the problem lies. But I agree. If it were me, to answer Joe's question, if it were me, I always err on the side of disclosure. Always. I just don't know if it's a law that they have to, and Anna didn't.
I'm going to second Marcia's motion to go with council's recommendation.
Okay, the motion on the floor made by Dr. Franks, seconded by Commissioner Bailey, is to accept council's recommendation. Further discussion? All right, hearing none, if you're in favor of that motion, these are the cases 36, 37, and 38. DJ, go ahead.
Pardon my being muted there, Chairman. The complainant is a resident. The complainant represented the property owner of a home. Is the complainant licensed? And do they receive compensation?
So deeper and say that again.
Do we know if the complainant is licensed? And I was wondering if they're not licensed, did they receive compensation from the property owner of this home who they represented the sale?
Commissioners?
That's Selena's first.
Yes, the complainant is licensed, I believe.
Ron, as the owner of the property, they can sell their own property without a license. Yeah.
Or running it through your company.
There is an ownership exemption. If you own the home, you can sell it without requiring a license. So that fall under 104, 6213-104.
But to DJ's point, in this narrative, the complainant is not the owner. The complainant is an agent representing the owner.
It just says a Tennessee resident.
Next sentence.
I didn't know that the complainant was a licensed broker or affiliate, but the council has confirmed that to be the case. So my question can be tabled.
In that same paragraph, it does say the complainant's clients were terribly upset.
Yes. Yeah. I'm good to still close it.
Okay, the motion on the floor, we can discuss it more if you'd like, is to accept council's recommendation on cases 36, 37, and 38 and close those cases. Further discussion? I hear none. Caitlin, let's see how the vote goes. If you're in favor of the motion, you'll vote aye. If you're opposed, you'll vote no.
Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferris.
Aye. Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Glenn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. All right, that motion passes. Let's go to number 45. Marcia?
Okay, so number 45 has all kinds of things going on here. And so it's the respondent was the property manager. Let's see, I'm trying to remember about the case. I'm wondering first how many properties were involved in this, because I see you have a civil penalty of $2,000 for the failure to respond to complaints, and also financial responsibility or insolvency. So there's two charges, and I'm wondering how many properties there were in all.
My understanding is that there was one property,
Okay.
and they were selling this particular property.
And did they ever get all of their rent payments? The owner?
No.
Okay, so this person is still holding money that belongs to someone else.
Correct.
Okay. So I'd like to, this kind of reminds me of the other one a while ago. I'm going to make a motion that we authorize formal charges and of a civil penalty in the amount of $2,000 and then suspend this affiliate broker's license. Do we want it 6 months or until they pay back the money to the people? Or does that have to be a definitive document?
Joe?
Marcia, it's showing that he's already retired his license and it expires in November this year.
Okay, I'm just trying to think, what can we do to him to make sure he doesn't come back in?
I'm with you. That's probably not going to hurt him too bad if he's already out.
Yeah. So can we assess this $1,000 penalty and not allow him for 6 months to bring his license out of retirement? Can we, Anna?
I don't think so. But we can require, we can always require someone if they want to reinstate or reapply to come before the commission to make a determination, if you would like that.
Okay. I'll make that my motion then, the $2,000. And should they reapply, they'll have to come before us, before the real estate commission to renew or get their license active.
Thanks, Steve.
Question. What does authorized formal charges actually mean? Does that mean we're filing a lawsuit in Chancery Court? What exactly does that mean?
So when the case is decided for the preliminary disciplinary action by the commission, they are sent a consent order with this opportunity to resolve the matter with whatever disciplinary action the board decides. If they choose not to sign the consent order and submit to the disciplinary action, whether it's a fine or coursework or suspension, then the case is brought before the commission in a hearing. And in that case, then the assessment of the penalty is open for the commission members to decide, as well as suspension, revocation, whatever the case may be. When I file those charges, I usually ask for everything, and then it's at the discretion of the board to decide what action they would like to take in the course of, the hearing.
So the person never got their money, the rent payments, is that correct, or do we know that?
That's correct. They did not receive all the rental payments.
So I'm trying to figure out, is it up to us to try to get their money for them, or is it up to them? Meaning, I would have filed some kind of chancery court on and gotten a lawyer and tried to get my money out of them, as opposed to asking us to do that, or are they asking us to do that?
A lot of the time, the complainants do ask us to do that, but unfortunately, that's not under our purview. We're dealing mainly with the licensing issue. What they should do is file a civil action in a court and recover their monies, and that would be separate and apart from whatever action we took.
Correct. So that's not what we're doing. We're not, when you say authorized formal charges, that's not us filing some kind of suit in chancery court or wherever to get their money, correct?
Correct.
Okay.
But Steve, this may be, the plan is to come to us first and then file the charges in civil court, and they will be able to say that the real estate commission found this person, guilty of these charges.
No, well, I guess that's a legal strategy, so to speak. I mean, I would probably be going after both barrels, us and the court, but I guess it costs money to do that as opposed to going to us, which costs no money. So, okay, I'm good.
Okay, so Marcia's made a motion to accept council's recommendation and flag the file in case this licensee shows back up to reactivate his or her license. They'll have to come before us first. Joe Bagley gave me a hand signal saying he seconded that motion. So it's properly on the floor. Is there any other discussion? If not, you've heard the motion. Caitlin, will you take the vote? If you're in favor, vote aye. If you're opposed, vote no.
Commissioner Joe Begley,
Aye.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Frank,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett, Commissioner John Moffett. I think I see an aye.
That'll work.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. All right, that motion passes. Let's go to 51.
Okay, on 51, given this is a principal broker, and I wanted to let everybody know that about a year and a half ago, there was a policy at TREC that if anyone was brought before us, that we filed charges against the principal broker also. We did away with that because we did realize that there are cases that principal brokers don't always know what's going on. But again, we do hold them to a higher standard because they're supposed to be over the agents in their office. In number 51, This is a civil penalty in the amount of $3,000 is the recommendation. And you can see the last paragraph. It's for making substantial and full misrepresentations, engaging in conduct that constitutes improper, fraudulent, or dishonest dealing, and failing to disclose to each party to the transaction any adverse facts, which the licensee has actual notice of knowledge pursuant to Tennessee Code, yada, yada. So, our counsel is telling us that their recommendation is that civil penalty, $1,000 for each of those three charges. Now, in the past, I really would like to. I'd like to help licensees to correct their behavior more than just give them monetary penalties. A lot of times, not a lot of times, but sometimes people look at it as a cost of doing business to get them around whatever they want to do, and it's just $1,000 penalty. When you're making lots more than $1,000, you can look at that as a cost of doing business. So in these cases where principal brokers are involved, I got with a great educator named John Giffen and worked with him on completing this core class for principal brokers. And you've every time today heard me say and give them that broker class. And the reason was there really wasn't anything to give them a class, but we do now have in our box this course that John Giffen gives, and it's a great course with everything in it that a principal broker needs to know. So I am in agreement with the recommendation on this one of $3,000 as a civil penalty. I also want to assess them also to do the class, the principal broker core class within 180 days and it not go to their CE credits. And that would be my motion.
Is there a second? DJ. Thank you. Okay, second by DJ Ferris. So the motion on the floor is to accept council's recommendation with an amendment that the licensee must complete the core class for principal brokers within 6 months. No credit for that class will apply to his or her license renewal requirements.
Chairman, can I get clarification really quickly?
Sure.
From either Caitlin or Ross, can you clarify how many providers we have for that principal broker class?
At present, we probably have only 2 or 3. I believe the only one I know for sure is trying to think.
But do we have more than one provider for the principal broker core class?
Well, yes, I'm trying to think out loud about it. The 2 that I know, the Nashville, the Tennessee Realtors and
Yes.
the Nashville Board of Realtors, I think.
Okay, I just wanted to make sure. Thank you.
Okay, the motion's on the floor. If you're in favor of the motion, when your name is called, you'll vote aye. If you're opposed, you'll vote no. Caitlin.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Glenn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torres,
Aye.
Chairman John Greer.
Yes. That motion passes. Number 55, Steve.
I've got a question from worship before we go on. Is the thing that you're trying to help them out because they didn't know what they were doing, or that? Because my thought is.
Wait a minute, Steve. I can't hear Steve. I can't understand him.
You're scrambled.
I got the background outside. It's possibly affecting it. So let me, I'll back to that. Is that works?
Steve, if you have a question, you can try putting it in the chat.
It's a long of a question.
Okay.
Is that better or is that worse?
It's
Same. All right. Let's move on.
John, you're muted.
Thank you. And probably should be. Shalina.
Yes.
On number 55. So this company out of Kansas City, is it offering the vacation lodging services?
Yes, and this is, the recommendation is incorrect. It shouldn't be
Okay.
closed. It's unlicensed activity.
$1,000.
Yes.
Okay. I'm going to look for a motion that would accept council's recommendation, which would be to offer a $1,000 civil penalty for unlicensed activity.
So moved.
Thanks, Jeff. Is there a second?
Second.
Thanks, Marcia. Okay, that's the motion. Is there discussion? All right, let's vote, Caitlin. If you're in favor, vote aye. If you're opposed, vote no.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Frank,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Greaves.
Yes. Okay, that motion passes. We're on to 56, Marcia.
Number 56 was for unlicensed activity. And the last sentence says the respondent is in the process of obtaining a vacation lodging service license and the application is pending. And my question is, this was opened May 8th of 2020. Has this person received their license, or do they still not have it all these months later, 4 months later?
When I reviewed this complaint, I double checked and it was still in pending status. It had not been issued. So I don't believe it's been issued since then, which would be roughly 10 days ago.
Okay, so what that is, I'm impressed with Caitlin and the TREC staff in that they're getting people licensed pretty quickly when people turn in all of their information. I don't see any reason to send a letter of instruction concerning license requirement when this person's practicing unlicensed activity. And for that, I would like to assess a civil penalty of $1,000 for unlicensed activity.
Mr. Diaz seconds that motion. Discussion. All right, let's vote, Caitlin. If you're in favor of the motion, offer $1,000 civil penalty, you'll vote aye. If you're opposed, you'll vote no.
Commissioner Joe Begley,
Aye.
Commissioner Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Frank,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Green.
Yes. All right, that motion passes. Number 57.
Okay, that was also me. And in this one, voted to revoke this person's license. I don't see when it was revoked.
Marcia,
Yes,
would you take a look at the recommendation? Oh, 57, right?
yes.
Would you look at the recommendation of council? See what you
The new
think.
recommendation.
Yeah, the new recommendation.
Yeah, it's that they appear before the commission for an informal conference. And what that does is that allows them to continue on when the commission has already voted to revoke this person's license. And I don't remember all the details of it, but I can tell you this. I've been on this commission for 6 years. There have been very few people that we have revoked. And when we have revoked them, there have been serious problems with this to revoke someone. And as you'll notice, it was a principal broker. You know, I'm wanting to know what's the disposition of this principal broker, and are they still a principal broker, or what's happened? And then we have the new recommendation that they appear before us. And I don't know why we need to even vote on this, because isn't anyone able to come back before us if they've been revoked?
Yes, well, in this was a very complex case, and this was brought before you prior to me being assigned to the Real Estate Commission. But in any event, they've asked that they be heard prior to submitting their application before the commission. So that's the request I'm making for them. They were expired on, I think their license expired March 31st, 2019. So when the revocation occurred, I believe they were already expired.
Okay, so they're not a principal broker anywhere that you know of?
No.
Okay. You know, I'm not inclined to do any special favors for someone we've revoked. I'm not inclined to tell them to come before us or not. We have another thing before us today, and it's a person who's been revoked, and they're going through the proper channels of coming back before us. I don't know why we should even take a vote on this one when it's not even going through the proper channels. So if I have to make a motion on it, that would be my motion, that we not reconsider this, and they need to go through the proper channels.
Okay, is there a second to that motion? Thank you, Joan. So it's officially on the floor. Shalina, my question is, I mean, a year has passed. I don't know how we could reactivate his or her license under any set of circumstances. Number one. And number two, just to comment, there's a lot of personal information in this narrative that probably shouldn't be in there, like the licensee's name. Just
Get
a
that
comment.
information redacted.
It's not redacted on what I have.
We'll get it redacted and
okay, perfect. So to my first comment, could we reactivate this licensee even if we wanted to, if it's been expired for more than a year? And I think the answer is no.
And it's not only expired, it's revoked.
I don't believe it's been revoked because there was not a hearing held.
We revoked the license, whether they signed it or not, I don't know.
And I do know that this one was an automatic revocation based on the respondent not filing the.
Are you talking about 6213 312F,
Yes.
where you're required to notify us of a conviction of one of the enumerated offenses?
Yes.
Let me take a look really quick. Hold on 1 second.
And that's something that the commission needs to know, is that we're talking about a felony.
The few revocations that we've done have always been, seems to me they've been automatic and statutory.
Caitlin, I'm looking at the information and it looks like they have an active license.
Principal broker active license?
Yes.
Possible. Oh my God.
I think if I remember correctly, this person sent us a notification before they went to prison. So I think that they did meet the 60-day requirement, and we opened a complaint against them based on the charge we presented before the commission. And if this person has not met the consent order that was offered and then did not agree to it, then it would be in the next stage, which would be either to authorize a formal hearing.
So let me clarify. There are two in 6213 312, which is the statute regarding discipline. There are two different provisions. 6213 312 B12 is when someone has been convicted of a enumerated offense, and they let us know. So that is what happened in this case. We were notified that this individual had been convicted, and yet the commission decided to revoke the license based on that. So this would not be the automatic revocation that is mentioned in 312F, because that is when we are not notified within 60 days.
So
I think the other issue, if I recall, with this one was that this respondent was in prison, and so I remember there being an issue getting service. Obviously, they're out now, and there's no issue with that. But I do remember over the course of time, there is a requirement to confirm service, I believe.
So, and well, whose fault is it when someone's in prison? It's not, I mean, that's a part of their punishment then.
Shalene, here's where I'm confused. You'd like for her to have an informal meeting with us when she could have a formal hearing, right? All she has to do is agree to it.
Yes.
Well, why don't you just ask her to agree to a formal hearing, and we'll cut out the informal part of it.
Right. I don't have to even ask. I could file the notice of hearing and charges, and we could have a formal hearing.
I mean, if she's got a case she wants to make, that's the place to do it.
That needs to be a motion. I'll make that motion, Mr. Chairman.
Okay, the motion would be to authorize council to skip it. What is it called, Shalena? What kind of document do you file? Notice of formal hearing?
Yes.
Okay, so that's the motion, Jeff. Is that okay? Is there a second to that motion?
Second.
Thank you, Marcia. So the motion on the floor is to authorize council to issue a notice of formal hearing to this licensee. Discussion. Those in favor of the motion will vote aye when Caitlin calls the roll.
Commissioner Joe Begley, Commissioner Jeff Diaz, Commissioner DJ Ferris,
Aye.
Vice Chair Bruce Shanks,
Aye.
Commissioner Steve Glenn, Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John.
Yes. All right, the motion passes. Marcia?
Mr. Chairman, I just looked up on the verifytn.gov. This person has an active license as a principal broker. I find that very disturbing. So if they're revoked, how are they still a principal broker?
Their license is not revoked. The commission voted to revoke their license.
Is that not the farthest we can downgrade their licenses to revoke it? I mean, you've got a person who has been to prison for stealing money, and they're a principal broker of a real estate company. That's stupid. I'm sorry, that's stupid. I mean, we put that on the books. We need a new rule for that. Then. That's very disturbing. That's not protecting the public at all. So what do we do? What can we do to this person?
So
Hearing charges need to be authorized on this one. That's the only way to move forward with since they did not accept the recommendation and the.
So meanwhile, it could be a year before we have the hearing and they're still principal broker.
So Marcia, there's one other option. And we very rarely use it, but it's a summary suspension pending a formal hearing. So I don't know what council would recommend in a case like this, but we do have the latitude to say the public is at risk. Usually this comes from council that makes the recommendation to us. And we think that there's such risk involved that we recommend you suspend the license until a formal hearing is held. I don't know Anna, what do you think? Is that the case here?
Ultimately, this is my opinion. This is Shalina's case. I'll let her make the final opinion. I believe that there's too much time has elapsed for a summary suspension. Those are supposed to occur within a fast amount of time. But I could also be very wrong in my understanding. That is just my opinion. I will defer to Shalina on her decision of where that will go.
Okay, Shalina, what do you think?
Well, as Anna said, typically these are brought very quickly to summary suspension, but in this case, this person has a license, and if you'd like to proceed with a summary suspension, we can. Of course, keep in mind that that would also involve a hearing ultimately. Initially, there would be a informal hearing held within a 7-day period to determine what action should be taken. So we certainly could move forward with a summary suspension in this case.
Well, I would like for us to do that. I remember there was one case, and to me, this is an emergency situation. It's an emergency. We did have one case where I remember it was done telephonically, and Austin McMullen, who was a commissioner at the time, and he and I were the Nashville commissioners. So we went to the TREC offices and we held a hearing along with all of our TREC attorneys and took emergency action on something. So it is something that we could do telephonically or by Zoom. It's even better. but I think this is an emergency, and that we need to take these. We need to get this person's license out of here until something else can be done.
The benefit of a summary suspension, I think, is it would get a formal hearing happening much quicker than just the normal process.
In terms of a preliminary decision on what action the commission should take, yes. But there would still be a formal hearing held on this.
Okay, Marcia.
That would be my motion then.
Your motion is to summarily suspend this licensee pending a hearing.
I have a question.
Go, Joe.
So the decision, the commission voted to revoke respondent's license based on what was the date?
The complaint was originally opened in October of 2018. I don't know the exact date it was brought before the commission, but it would be soon thereafter.
The disturbing part for me is that, of course, I wasn't here at that time, but I don't know if Marcia was or John.
I was.
But, you know, they made a decision to revoke respondent's license, and you kind of go to bed thinking, you know, that's being handled, or we're going to know about it if there's a problem. And then we're 2 years later that we find out they're still licensed and legal and operating, you know? It's kind of weird.
It's very disturbing is what it is.
I mean, at least they were in prison in the meantime, right?
Yeah, but they've been out for 2 years. They've been out for 2 years.
Okay, so let's get back to business. Marcia has made a motion that if it passes, would authorize staff to summarily suspend this licensee pending an informal hearing, Shalina, followed by a formal hearing. Is that right?
Yes, I would begin the summary suspension process, and there would be a informal hearing held, and then a formal.
Okay, is there a second to Marcia's motion? Thank you, Jeff. Steve, I just missed you. Discussion. I didn't hear you, Steve. You're garbled.
Still garbled. Okay. All right. I'm gonna move downstairs there a little bit. I'd like to know more about when we revoke a license. What timing happens? In other words, is it a delay game? Meaning they can just continue practicing real estate for a couple of years or what?
So, Steve,
Joe's like that, actually.
I didn't understand you, but it sounded like you were making a ransom call. Okay. Just a thought. Okay.
I think he said he would like to know about the timing when when the commission votes to revoke a license.
Okay, staff or council will have to speak to that.
In terms of, are you asking about the informal hearing?
I think he's asking, like, in a typical situation, if the commission voted to revoke a license, what the process would be.
Well, the process would begin with filing the notice of hearing and charges, and then there's 30 days given to the respondent before a hearing is set. And as soon as we can set that hearing based on just available dates of the commission and the administrative law judge, that would be set for a hearing. So it just varies. It ranged between 3 months to 2 years before hearing is brought.
Okay, thank you.
John, I think you're on mute still. You're on mute.
Damn it. If you're in favor of the motion offered by Marcia and seconded by Jeff, you'll vote yes. If you're opposed, you'll vote no. Caitlin?
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Harris,
Yes.
Chair Marcia Frank,
Yes.
I couldn't hear you, Marcia.
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Yes.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. All right, that motion passes. We're on to case 58, and for those of you not keeping track, we have two more after this one, 58. Marcia?
Okay, so my question on number 58 is, so we had a recommendation and a decision, and then we had new information. Now we have a new recommendation to close. And it looks like all the new information came from the respondent. And I'm wondering, did council reach out to the complainant to get their response to the respondent's new information?
Oh, no, this was not submitted to the complainant. The respondent provided me the checks, and that's what I reviewed and I checked on. This case was brought before I was assigned to the Real Estate Commission. But based on my review of the entire case, as well as the recent documents that were provided, the checks were issued from a operating account and not an escrow account. And that's the reason for my recommendation to close, because the checks were not available previously.
Okay, and then it also says in the respondent's their new information, the only thing to add here is that the complainant continues to sell homes owned by the LLC. So I'm wondering about that complainant and the LLC selling property through an LLC. The complainant is a licensee, correct?
Yes.
Okay, I'll move to accept council's recommendation to close.
Is there a second? Thank you, Jeff. You've heard the motion. If you're in favor of it, please vote aye when your name is called. Caitlin?
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Harris,
Aye.
Vice Chair Marcia Frank,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes, but the motion passes. Number 69. Erica, I thought we would never get to you.
I'm right there with you.
Have you been?
Wonderful.
John, you
What are you
missed
doing?
59 too.
59?
That was one of yours.
I don't have it on my list.
It was one of yours.
We'll come back to it. Let's get Erica.
Okay, hi, Erica.
Hi, it's so nice to see everybody.
Where are you now?
Oh, what boards you mean?
Yeah.
The Motor Vehicle Commission, the Land Surveyor Board, and Geologist and Soil Scientist.
And so you dropped back by to see us because of a couple of old cases.
Yes, the backlog that there's one more outside of this one, but yeah, this is it.
Well, let's get started.
Okay.
Martha, 69. Marcia, you're muted.
Sorry. Let me get to 69. Okay, so the new information is what I'm not understanding. What is the new evidence?
Well, this is the principal broker for the affiliate broker in the complaint above. So all the new evidence is what I presented in the affiliate broker summary. And based on that, I didn't see that there's even a possibility that there was a failure to supervise by a principal broker because I didn't see any violations by the affiliate broker based on the new information.
Okay, John, did you have a question about that one?
Nope.
Okay, then I move to accept council's recommendation to dismiss.
Is there a second? Jeff Diaz, seconds. Discussion. When your name is called, if you're in favor of the motion, vote aye. Otherwise, vote no. Caitlin.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz, Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Frank,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffitt,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Aye. The motion passes. All right, number 70, Marcia. You're mute. Marcia, muted.
I'm sorry. I'm so sorry.
That's okay.
I said I have 2 pages of notes on this one thing. I'm not going to go over all that. The number one question was, is this unlicensed activity or not?
Well, the respondent owns all of the properties that they manage and rent out, kind of as short-term rentals. So, and the owner of that respondent company, their wife is a licensed agent as well. So from the statements made by the respondent and their attorney, they don't understand how it could be unlicensed activity if they own the properties. And they said if they ever do anything that needs a licensee, they use the licensed agent that works for their company. So unless they need a firm license, I don't see that it's unlicensed activity.
So you do know what company? Well, first of all, this started out with a 19-year-old guy newly here from Egypt. And he was told by this owner of these properties to advertise these properties, which he did. And it shows that were you the person on this case, Erica?
Yes.
So it showed that you believed him.
I did.
Okay.
But I had not spoken to the respondent in this case, his employer at all at that time, because we didn't even have a complaint open.
Okay. So you believed him, and then the respondent says, no, I didn't tell him to do those things. So now you're saying, but even if he did tell him to do those things, he did have a wife that's a real estate licensee. But at the same time, they're also talking about they had a newborn in the NICU for 10 months and that they were at the hospital with this person. I mean, with their child, and this other person, the 19-year-old guy he was telling to do all this, was handling this stuff for him while they were at the hospital.
Right. The respondent hired this 19-year-old when they had their newborn, and there was major medical issues that kept the owner from, I guess, taking care of things as they should for their own properties that they own. So originally, I thought there was a huge problem with the respondent telling the 19-year-old, okay, you can post these, because I didn't know they owned the properties. So I thought, well, that's unlicensed activity no matter what way you look at it. But now that I know they own them, I don't really see a problem with it, other than I think the 19-year-old used poor wording. And from the text that the 19-year-old gave me, he would say to the respondent, send him a screenshot of some of the ads that he would put onto social media. Can I post this? And there'd be like one word by the respondent, and it would say, "This is great" or "great." And I have a few of those, but that again is when I didn't realize they owned it. They own these properties.
Yeah, but and you have proof. You have proof they own them. You have deeds.
No, well, I don't have deeds. I just took their statements from the attorney and their own statements. Now I can get proof, but I don't have deeds.
All right, so you have no proof. But what we do know is this man, the 19-year-old, was doing unlicensed activity directed by this other person, and he submitted his text that showed that this man told him yes to do it.
For an example, something that he asked them to approve, which I thought at the time was unlicensed activity because I didn't know they owned the property. He would say something like, "So happy to be a part of these gentlemen's journey to find their best fit 2-bedroom, 1-bath remodeled rental." So that kind of thing. It was never like, I'm a real estate company and I want to find a property for you that I don't, own. I just thought it was unlicensed. He also called himself the employee on his Facebook page. It said property manager for respondent company. So that's where when I was talking about unlicensed activity, that is what I meant, not necessarily the things that he posted on his social media about certain rental properties.
So what's changed about that then?
Well,
he said he was a property manager and he wasn't.
Well, we sent a letter of warning to him and he got licensed. He's been licensed. So that was
after the fact.
Taken down. Oh no, it was immediately taken down.
But after he did the unlicensed activity and we sent him a letter, then he got a license. So we know he was unlicensed.
Yes, he got a license and quit the respondent's company.
All right, so I think this is two different things. There's nothing wrong with the man who owns the property selling his property, but on the other hand, there was this person who was doing unlicensed activity, has admitted to it. The other guy says he did it. The problem comes that this man took advantage of this 19-year-old guy, paid him $5 an hour and made him work 80 hours a week, right?
Yeah.
Jeff.
And so do you know that the wife was involved in this property management, even though her child was in the NICU for 10 months?
Well, from what the respondent stated, it was more of a statement that anytime we needed a licensed agent to be involved, we had a licensed agent involved. But during that time, there was no activity going on.
Except that they were advertising.
Except for the employee was posting on their social media. On their own personal social media. Like Instagram. Like I have a picture, look at me, I just helped these people find a rental. Or
and so do you know the wife is with a company with a company at that time?
That's what they said, yes.
What did they?
That's what the respondent and their attorney stated to me in a.
But they didn't provide any proof that she was licensed at that time?
No.
Do we know she was licensed at that time, I guess is the question.
Well, I didn't even ask for the wife's name because there's no allegations against the wife or against that there's any properties that they don't own. But
well, I guess I need to bring this one back whenever we have the name of their company. How their
I just have problems with, they have a lawyer, and just because the lawyer said something that we are supposed to believe it's truth with no evidence or proof.
I guess I'm not really sure because there's no specific allegations against this respondent. It was opened administratively as a result of a complaint against this employee, I'm not really sure what to ask for other than, what's your license number? And I mean, is that all you want me to look into, is just to verify that the wife is licensed?
Well, but what you're saying though too is that this was unlicensed activity by this person.
By the employee, by calling
Yeah.
himself a property manager.
Yeah.
I think we would also need, Erica, the deeds showing that they did own the properties and how their company is set up. Because, if they're set up as an LLC, they would be required to be licensed, even if they did own the properties through the LLC.
And the wife being the attorney should have paperwork too that she could submit showing, that's the agent. The wife would have paperwork too, wouldn't she? With her name on it?
For paperwork showing what?
The property management that was going on or whatever they were doing.
So basically maybe have sort of an audit of their records at that time, what properties they were renting out, and then get the deeds to those to show that they own them, and also that the wife was licensed during that time.
Yes.
Okay, I can definitely do that.
So, Marcia, you want to postpone for 30 days?
Yeah, let's defer it for 30 days.
Is there a second? Thank you, Jeff. So this has been going on, Erica, for 2.5 years, right?
Yes. I mean, it's been open for that long. Well,
when could the respondent have hired an attorney? Early on, right?
Yes.
This drives me crazy that we have cases like this that just linger and linger and linger. And I'm not
because somebody can afford an attorney.
Yeah.
Well, I'm not trying to make an argument for them, but when they were presented with this complaint, they had no idea there was any sort of allegations that they were, engaged in unlicensed property management. It was more about, why did you let an employee call himself a property manager? And they responded to that immediately. And we had to do some back and forth and me explain, well, you have this website that you kind of call yourself property managers. And then that was when they said, well, what are you talking about? We own these properties. They were kind of dumbfounded as to, we don't know what this is about. So it was a lot of communication.
Well, isn't the respondent the employee, for lack of a better term? It's not the owners of the property.
The employee had a separate complaint that was open first. Once I presented it to you against the employee, that's when we decided to open up a complaint against this respondent to look to see if they're engaged.
I got it. So the motion is to defer for 30 days. Is there discussion? Okay, let's vote. Caitlin, if you agree to defer for 30 days while council gets more information, you'll vote aye. If you're opposed, you'll vote no.
Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferris.
Aye.
Commissioner or Vice Chair Marcia Franks.
Aye.
Commissioner Steve Gwynn.
Aye.
Commissioner John Moffitt.
Aye.
Commissioner Joan Smith.
Aye.
Commissioner Stacy Torbett.
You're muted, Stacy.
Sorry, aye.
Chairman John Grease.
Yes. Okay, that motion passes. All right, here's some good news. I did not pull out case 59, so we are done with the legal report. Shalina, Erica, Anna, thank you. Hey, Shalina, I just have one quick suggestion.
Yes.
So somebody in legal department determined that if a complaint in a timeshare case is filed 2 years after the alleged event, there's no need to hear it because the statute of limitations prohibits anything from happening. I hate reading timeshare cases because I know who's going to win every one of them. So if it's more than 2 years old, if you could just put in there the time statute of limitations causes us not to have to review this case, would be perfect. What do you think?
Okay, sure. I can do that.
I don't know if it's true, but I love the logic behind it. I hope it's true.
Yes.
Okay, legal, Anna, Shalina, Erica, any other items to come for us?
I don't believe so. That's all. Thank you.
Thank you for your hard work. Erica, nothing, right?
What did you say?
I said, go back to geology or some other place. We'll see you next time.
Motor Vehicle Commission is what takes up all my time.
I'll edit it.
Erica, you're going to miss us. You know it.
Yeah.
I do. But I'll be seeing you next month. So.
Okay. Anna, anything from legal?
I do not have anything.
Okay, perfect. We're still open-ended about whether we're going to meet in person or by WebEx next month, but we'll get that as soon as the governor gives us some direction. Kate, anything else from you?
Nothing else from me. Thank you guys for your time.
Chairman,
Okay,
can I clarify what direction you're looking for from the governor?
Well, I still hold out hope that we could meet in person in October.
Well, the executive order in place runs until 10/28/2020, until the end of October. So I don't foresee something coming between now and then.
That just means John wants to go to Jimmy Kelly. That's all.
Hey, they're back open. Did you see the newspaper article? So
Joe wants to go too.
boy, Joe.
What keeps us from coming to Nashville and
Stop
doing
for a
the
French fry. Come
WebEx
on
from the
now.
hotel?
So let me just follow up for a second on this. So it's possible we'll have an informal hearing on the summary suspension sometime the next week to 10 days. Is that right, Anna?
Yes, that's correct. And it will be done by WebEx.
Okay, Shalina said that. Okay. I didn't say. So because of the governor's order, does that mean we can't meet in person or we have the option to meet virtually?
Anna?
For the October meeting,
Yes.
it is extended virtual meetings through October.
I know it extends them, but does that mean we have to do them? It just gives us a right to do them.
We don't have to do them,
So-
but when we spoke about it beforehand, I don't know how it would go over us deciding not to go to Chattanooga, but going to Nashville, if that makes sense. That seems like a precarious decision to not go to Chattanooga and then instead going to Nashville. I feel like if we're not going to meet in Chattanooga, we probably need to just meet virtually.
Okay, so I say it's still open as to where we're going to meet next month.
But Juan, Anna, I asked Anna, would staff be able to come to Chattanooga? And she said they would not with the order through the end of October. And we can't go to Chattanooga and have a meeting and hearing without the staff.
No, we'll leave it open at the moment.
Okay.
I think I know what's going to happen, but I hate what I think, but we'll leave it open. I'm about done. All right.
So I will tell the judge tomorrow. But it may be that the hearing takes place virtually.
Okay.
And so I'll just let you know that.
That's perfect.
I'd like to say something about that, John. So will there be another, was I the only one that wasn't on the class of how to do the hearing with WebEx?
I think so.
So
Okay, so somehow I need to know how to do that. If there's another chance that I could do that. And the other
Martha,
thing is,
I'll email you. I got 3 other dates.
Great.
The problem
Great.
was we thought we were going to have the hearing tomorrow, and so that was the only date prior
okay.
tomorrow. But there are 3 other dates at the end of September.
Now, the other problem with that is this. I cannot imagine, like I said earlier, doing a WebEx for a hearing with the issues that we had today. It's very important that we be able to hear Steve. We could not hear Steve. Why is there no way we could not change from WebEx to that for a hearing and do it on a Zoom? I've been to all kinds of Zoom meetings and not one problem.
Zoom has really bad security features.
Well, I mean, I do it with boards and bank boards and stuff. So
Also, the Administrative Procedures Division uses WebEx. So that's the court's decision, not our decision.
There is a link that I believe I sent out to the commission where you can test your WebEx. It's solely a test link. That might be a good thing for everyone
I got
to do.
that, and that's just like, how do you come on Zoom? I mean, that was.
You can test your microphone.
So, did you all go over how someone has to keep up with all the facts and the conclusion of law and all that? John?
Here's what I know, Marcia. Caitlin sent us a PowerPoint presentation that you ought to take a look at.
I haven't seen it. I didn't get it.
Well, she'll resend it. Okay. All right. Let's go, commissioners. Let's see if you've got anything you want to say. Joe?
I'm good. Thank you.
All right, Stacy?
No, Marcia, you'd mentioned earlier you wanted to talk about the materials we get before these meetings. Did you still want to talk about that?
Oh, I did. It was just about that if everybody will like write down which ones they want to pull out, and just being prepared for it. That's all. Nobody ever told me to do that, and then I realized after a couple of months that, oh, we're supposed to read this stuff before we come, because I was trying to focus on all these individual cases, and if you can prepare your mind and your thoughts and decisions beforehand by reading it. That's all, Stacy. Thank you, though.
So, Stacy, are you going to the beach or bike riding, golf? What are you going to do?
Well, it looks like it's about to rain, so I may be doing nothing.
Come on, do something. Thanks for joining us. John Moffett, anything?
Yeah.
Can't hear you.
Well, I just hope the formal hearing in person, I can tell.
I agree. Okay, DJ?
I agree. I like the meeting in person. Appreciate everybody's effort today. I'm fast tracked and up to peace.
Thank you, DJ. Steve?
Sorry about that. I don't know. It'll get better now. Still going.
Steve, you're still gargling.
Okay. I'm going downstairs next month.
Okay. Marcia, any final comments?
I just wanted to let everybody know, Caitlin, I wanted to ask Caitlin, who did she register for the Arello conference?
I registered staff, myself, Anna, and Ross.
You didn't register any of our commissioners?
Last month, when I reached out to everyone, when it was free, there was no interest in attending on Zoom.
Okay, that's all.
But you have registered Marcia, right, Caitlin?
I reached out to Marcia, and she does not need to be registered.
Oh yeah, she's
it's only $75 a person, so if you wanted to be registered, it's not much.
Dixie. Is that Dixie?
No.
Oh man, Jeff. Any closing comments?
A quick one for Caitlin. Has there been a 2021 calendar out for our meetings yet? I haven't seen it, so.
I will send out the one that the commission voted on last month. It is now on the website, but I'll make sure
Okay.
everybody gets a copy of
Okay.
the official calendar.
Okay, and Stacy, playing golf in the rain is fun. You should go.
All right, Joan Smith, any comments?
No, thank you so much though for asking, and I got to make my first motion today. Thank you for that.
Way to go. You did good. Just a couple of things. We'll be done. I've calculated that each of you commissioners today has made $12.50 an hour participating. So congratulations on that. Number one. And number two, I'd be remiss if I didn't mention that Marcia is going to be installed as president of ARELO, Association of Real Estate Licensed Law Officials, this month at their meeting. It's a high honor, and ARELO is fortunate to get somebody that cares enough to want to do that job. So congratulations, Marcia, once again. It's a compliment to you, but it's also a compliment because she's the first person ever from the state of Tennessee to be elected to that position. It's a big deal, and I just want to recognize it.
Thank you, John.
Congratulations.
Thank you. Thank you.
With that said, guys, I know meeting virtually is a pain in the tail. It is for me. I appreciate your attendance, your persistence, and would like to finish up by echoing what Marcia said, and that's you need to feel free to participate. The people who filed complaints and the people who had complaints filed against them deserve to have the type of review that we've given today. So it takes a little more time sometimes, but that's what you're appointed to do. So with that in mind, I wish you all the best. It's 12:30 in Nashville, 1:30 in Knoxville. Let's go eat. Have a great day. Bye-bye.
Thanks.
See ya.